one group, one group to new appeal for inclusion in the list.
Today is not the mentioning day. Come, oh, kalke chutti, huh? New application, or it was hard earlier?
No, one actually new application.
Yes, call the list.
Wait, please, your Lordship, my lord.
Lordship, in item 1, Dr. Patra is appearing for the commission, my lord. Today he has some personal difficulty. I am praying for not this week, my lord. And also we have not received instruction in the matter, my lord.
Madam, this is the, I think, the fourth occasion. Hard occasion, I think. Time has been taken. So if your officers are not willing to give you instruction, we will ask them to be personally present.
Last chance may be given, my lord. Kindly keep it on Monday.
Last order was on 25th September.
Yes, my lord.
Now thereafter, if your officers have not given you instruction, we should call the concerned officer. He's not abiding by what you are saying. When do you want it? Tell us.
Monday, my lord.
No, tell us the date. If your officer doesn't give you instruction, we will, so that we can pass appropriate order. Give us the date.
3rd, my lord. 3rd of November, my lord.
3rd is monthly list. It will be on 4th.
Grateful, my lord.
Lordship, I'm appearing for the state respondent, my lord. My lord, I appear for the petitioner. My lord, that matter where, my lord, minor girl was missing since 2003, my lord. I mean, it's my petitioner.
Yes, tell us.
On the last occasion, my lord had directed me to file my list of dates, my lord. Prepare a list of dates and file it for your lordship's convenience, my lord.
Lordship, the same direction was upon us also, that the CID should also file a list of dates, since this was a matter pertaining to the year 2003, and subsequently in 2024 they approached before this honorable court, and there was an order by the honorable coordinate bench to investigate the matter by the CID, since a video recording was produced before the honorable coordinate bench, and it was directed to interrogate those persons, and we interrogated those persons. Subsequently, the accused persons went up to the honorable apex court, and apex court was pleased to set aside the order of the honorable coordinate bench, and subsequently this the investigation was continuing. But now we were in a position, since we were continuing this investigation after that order passed by the honorable coordinate bench, we investigated the matter. The persons who featured in those particular videos that was produced before the honorable coordinate bench, they negated the entire thing, that we didn't make such a statement, and we don't know anything about the matter, that we have submitted in our report in the last occasion itself. Now they approached this court actually after 22 years. This was one of the reason that we could not recover this particular lady.
But the complaint was lodged in due time.
It was lodged in 2003, my lord.
Public interest done on that basis.
Lordship,
Did not take any step.
No steps
That
were
is why
taken.
CID direction.
Initially,
My clients were discharged by the learned magistrate. That order was challenged in a criminal revision. In the criminal revision,
We are not on that. We are on investigation.
Yes, my lord. On 2003, initially the Badipur police station took up the investigation, and subsequently they filed a charge. After completion of the investigation, they filed a charge sheet before the Ladder trial court itself.
When was it?
Lordship, the charge sheet was filed in 2005, my lord.
I see. Then?
And after filing of the charge sheet in 2006, a reinvestigation was again ordered. Subsequently, in 2006, after completion of that reinvestigation, again charge sheet was filed on 1st September 2006, my lord.
Then what happened?
Lordship, they were subsequently discharged.
That was in 2014, no?
23, my lord.
No, my lord.
2023. Discharge is in 2023. And not
All
all
the
accused
accused
persons
have
also.
been discharged.
No, my lord. One is
Oh,
still the
except-
main accused, my lord. He is still the trial is still ongoing.
Yes, my lord.
What is the stage of that trial?
My lord, the state, my lord, the CID had initially prayed for polygraph test. Thereafter, my lord, before the Honorable Apex Court, on their affidavit, they have stated that they have no problem if the accused persons are discharged. My lord, my allegation from the very beginning, since I received the report of the CID, is that the CID is in hand in gloves with the accused persons. They are trying to guard the accused persons. My lord, in 2005, the charge sheet was filed.
Will be established in the trial.
My lord, that may be established in the
We are
trial.
in habeas.
Yes, my lord. My lord, habeas corpus.
How can we keep the matter pending for traceability of a minor who went missing in 2003?
My lord, kindly appreciates one thing, my lord. We have also filed review petition before the Honorable Supreme Court, my lord, against the order of discharge of the 5 other accused persons.
So when is it? It is
My lord,
reviewed by HON'BLE, sir.
My lord, the ID number, my lord, it is here, and my lord, might be around the second week of November, it will be heard, my lord.
29th July, another date.
CRR to disposed of. 29 July 25.
Clarification of about the pendency of this habeas corpus.
When was that order passed? That Supreme Court set it aside.
Yes.
Where is that order? What is the date of that order?
Supreme
Well,
Court
that was
certified
passed on 19th August 2025. Order to my
Yeah,
lord.
there was
19th August 2025.
19th August 2025. আরেকটা কপি দেওয়া নেই তো?
দুটো কপি দেওয়া আছে
19th August or 19th May?
19th August.
19th August.
So you have preferred review against this order.
My lord, I have prepared review against this order.
You are for whom?
I am for the private arrest.
5 to 11.
The accused persons. My lord, our order, the order discharging us has been affirmed by the honorable.
We know, but he has went for review of
Yes,
that
my lord.
order.
Here is the diary number.
এটা তো আলাদা কিন্তু habeas corpus
Now, my lord, so
discharge হোক না হোক তারা ট্রায়ালে বোঝা যাবে কিন্তু habeas corpus টা দিনের পর দিন পেন্ডিং দেখো ওখানে ওটা পরিষ্কার কথা বলেছে যে এরা আমাদের আর কি করার নেই CID
Pardon.
I mean,
Not yet, my lord.
charges have been framed.
Charges have been framed only against the one accused person, my lord.
Very good.
The
When
other.
was that done?
My lord, the next date, my lord, is in sometime in 2026, my lord. That next date of trial. I mean, the before the trial court, my
my
lord.
lord, he is facing trial before the juvenile justice court. The husband with whom the girl got married. My lord,
Even the review application is allowed.
My lord.
And the order setting aside the criminal proceeding
My lord.
is affirmed.
My lord.
Then what impact will it have on the habeas corpus? Habeas corpus is a totally different aspect. The coordinate bench in its wisdom had directed, while considering habeas corpus, passed some order on the criminal revision also.
My lord.
But you have to satisfy us that why should we proceed with the habeas corpus?
My lord.
You are approaching before your trial is pending.
My lord.
So the dispute whether the girl had expired because that body was found and something.
But my lord, no conclusive
Sir, those facts
CFSL
are to
report.
be, we understand that those facts have to be established in the criminal proceeding. Sir, please try to understand. This is a prerogative writ which you are applying.
Lord, the habeas, my lord, as far as my lord, whatever I could, my lord, research and find out, my lord, habeas corpus in a habeas corpus writ petition, my lord, I have to satisfy your lordships on 2 points. That, my lord, one is
He in
illegal detention, my lord, and my lord, that
How can you establish that
Lord,
illegal
because
detention?
in CID report, my lord, CID report, it is specifically stated that the missing girl, she was last found with the alleged husband of the, I
Who
mean,
is still in custody?
who is still in, he's not in custody, my lord. They are
Trial is commencing, trial is pending.
only against them, only against that person,
Right. So,
husband.
that will be the merit of the criminal proceeding.
Well, a contrary observation is in the Supreme Court's order. At least is paragraph 8 of the Honorable Supreme Court's order. Absolutely a different observation.
What is the review application?
My lord, it is observed that it is a matter of fact that the victim was lastly present in the house of the complainant, from where she was found to be missing. My lord, that is the observation recorded in the Honorable Supreme Court's order, paragraph 8.
My lord, CID's report, my lord,
Absolutely
states
contrary observation, my lord. The claim of the petition is that she went missing from the custody of the husband. My lord, it's not that. That is the report submitted by the investigation agency before all the courts.
You understand you have been discharged on the basis of that there have been subsequent. The habeas corpus is restricted
that
to
is
the
different.
person and the place. So if the by review that order is recalled, then it gives rise to a different fact scenario. But still, it will be the issue before the criminal court. Habeas corpus, we cannot interfere at this stage. Interfere in the sense we cannot further interfere. We understand your anxiety, but sir, how can we help you? Tell us.
my lord, either my lord, the victim girl, my lord, either
Whether the girl has expired or the girl is still missing, whether there is any contribution of the person and the other persons, these are all subject matter of a criminal proceeding. That is the jurisdictional criminal court will take steps.
my lord,
But you have to understand, na, there is no use keeping a litigation pending. You tell us that you alright, you dispose it of with appropriate observation that this will not be having any effect on the criminal proceeding. But you have to satisfy yourself. Na? We understand you are the anxiety of the petitioners, but how can we help you? Tell us or show us something that Supreme Court has said that criminal proceeding, whatever it is in habeas corpus, we should also proceed.
but then my lord, if my lord gives me one
The
accommodation, my lord,
hardened
then I'll
issue we facing is
Right.
2003, the girl went missing. We are in 2026.
kind of
25.
Mr. Bhaktul.
my lord,
You are Mr.
Abhijit Roy Choudhury, my lord.
Who is Mr. Bhaktul? Your junior?
No, my lord, he's from the chamber, my lord. One of the
Same
chamber.
office.
Same office, my lord.
Ashok,
One occasion he appeared, my lord. I was ill that day.
Mr. Roy Choudhury.
For the petitioner.
Yes,
I have informed CWC not to give adoption.
So the last person, your lordship, CWC was a party. Your lordship, till date, my child is missing and it's in custody of
CWC party add করলো
so
add করলো party টাকা দিয়ে নিয়েছিল
this your case.
on 23rd of March 2025, I was born my newborn baby boy. Thereafter, your lordship, one of my family relatives taking care of my children for their betterment. After that, 8 of May 2025, the falsely implication the child theft from the Lilua Children's Home. Police was taking this child forcefully, illegally, and take this baby to the Lilua Children's Home.
Where you have said that this is the child is how many years?
The child is born on March, your lordship. It's about 6
March
months,
25.
6 month plus, your lordship.
So come to paragraph 4, what you have stated. Entrusted the care and custody to husband's uncle's sister.
The husband, uncle, sister, not your lordship. It's I mentioned in my representation, your lordship. Kindly come to page number 17, your lordship. There's a page number 17, your lordship.
17.
Your lordship.
No, she was forcibly taken away from the custody of the persons to whom you handed over custody.
Yes, your lordship.
So where is the complaint to that effect?
17, page number 17.
17.
70, on
That
17.
is after 3 months.
No, your lordship. Several representation I was made. It is the
That you have
Resha
not
one.
stated. That you have not stated. Paragraph 4, paragraph 5.
with the
On about 7th May, forcibly took away custody.
my past
Then
representation was
police authorities demanded money. The story was there. Called for Lilua. Petitioner was called for Lilua Children's Home. First representation on 18th of June 25. Where is
18th of
that
June
representation?
2025.
আমরা কোনো খবর পেলেই আমরা যাব এবং সেটা জুভেনাইল জাস্টিস অ্যাক্ট অনুযায়ী আমরা প্রোটেক্টিভ স্টে একদিনের জন্য রাখবো হোমে, তারপরে সিডব্লিউসি করবো। সিডব্লিউসি বলেছে আমরা তার জন্য হোমে,
এই আপনার একটু ওই বইটা বের করে দাও তো, জুভেনাইল জাস্টিস।
তারপরে আমরা কাগজে নোটিফিকেশন দিয়েছিলাম, তারপরে পাবলিকেশনের পরেও আসেনি, তারপরে আমরা ফিট ফর অ্যাডপশন করেছি।
Yes, then what happened? After the representation
After the
made on 6th
representation-
August, nothing took place. So did you lodge any? Who is for the state? You are for the state?
Yes.
So tell us, Mr. Dev, what
But
happened?
I tell you, lordship. My lord, source information was gathered that my lord, a baby of 1.5 months was abandoned by mother for a sum of money. Then my lord, for illegal adoption to be taken place. Police my lord recovered the baby, waited for 1 day as required under the law,
জুভেনাইল
then
জাস্টিস
Juvenile Justice Act. Then my lord handed over to the CWC.
হোম।
Waited for 1 day for what? For the mother to come and take custody?
No. My lord, the day when it was recovered from that lady Jarina,
Yes.
next day, my lord, it was given to the CWC.
Yes.
for protection of the and stay of the baby. Then it was given to the my lord home.
Very good. CWC was got the custody of the child.
Then thereafter handed over to the my lord home. CWC cannot keep the baby.
The sponsor to the recognized home they handed over. Now in the home, she is there. The
She is there.
child is there.
Yes,
Now what about the fresh adoption proceeding?
my lord,
We have informed.
we have informed by publication of in the paper.
That the court order is there. You
Court order is there not to give in adoption. We have informed. Last order of your
Mr.
lord.
Dev, what is the procedure now? CW?
My lord, if it is abandoned, then my lord, it is given in adoption.
No, we can send her to the CW.
Yes, yes, no difficulty.
No, what we will direct, what we will direct. But suppose if the interim order goes before taking consequences,
My lord, if the mother wants to take the baby,
yes,
naturally it goes to the natural mother, parents.
there must be a provision to that effect in the statute.
My lord, difficulty is, my lord, she has already, I have given it earlier also. Earlier,
He said that I will not take the child.
yes.
No, but suppose we can, how we can relegate it that where is the provision that CWC in respect of an abandoned child, what is the procedure to be followed by CW?
If it is abandoned, then it would give it to the
Under
prospective.
which provision, please show us, Mr. De.
My lord, book has not come today.
That we have not brought the book, my lord, Juvenile Justice Act, relevant provisions.
Assist us. Otherwise, how can we direct? You talk with your CWC. That what
CWC is not coming forward. That's the real difficulty. I have informed.
Who has been added as a party.
Added as a party,
You
আমরা
have
জানি
served the party.
stay
You have
করেছে।
served the application upon
I
CWC.
have third copies to
আমাকে
Not,
বললে
not
হবে না।
to me.
Sir,
CWC
আপনি আমাকে
আমি
বললেন যে আমাকে
দিয়েছি।
দিয়ে দিন, আমি দিয়ে দেবো আমার পাশে
না, 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 না।
কিন্তু একটা তোমাকেও পাঠিয়ে দিতে বলেছিলেন জজ স্যার।
তারপরে তো আমার সাথে কথা বলে আমি বললাম আমাকে হাতে হাতে দিয়ে
My lord,
দিন।
let the copy be served to the CWC.
You are appearing, Mr. De. CWC, you are appearing.
I can appear.
No,
Sure.
But if they are not coming forward,
we have said that you will avail
Yes,
the
yes.
instruction.
Will also appear on behalf of CWC.
I also stated on the other day. Your lordship stated that additional government pleader appearing for the state respondent can appear on behalf of the CWC service of a fresh copy of the writ petition upon the added respondent is dispensed with.
সেজন্য ওনাকে দিয়ে দেয়।
That is why, my lord, we are repeatedly asking, not coming.
Then tell us who is the person concerned. We will take appropriate.
Member secretary, na?
CWC member.
Member secretary, তাই তো?
Why he will not come to give you instruction?
My
We
lord,
are not asking for personal appearance.
No, I know. But then if no instruction comes,
Senior, you're a senior counselor. How do they dare to not to hear to you?
my lord, give another chance so that I will try again personally. It was through my junior previously. এই নাম্বার
An
আছে
earlier order dated 25th
সঙ্গে থাকছে আর কি, বলছে মাকে
একটা you are
hearing in this matter for the petitioner, my lords. Due to certain personal inconveniences, he is unable to appear before your lordship.
এগুলো এক কপি করে আমার কাছে পাঠিয়ে দিল।
I'm praying for not to remember.
রাখো এখন।
not today. Yes.
কবে দিয়েছো?
Next.
ফাইভ আমরা
কবে?
6-এ আছি।
Lordship, affidavit service has been completed.
Service complete.
Yes, Lordship.
Service complete.
Yes, Lordship.
Yes, tell us what is. Yes, tell us what is the matter.
Lordship, on 30th of May 2024, yes, 5, 2 minor children were taken custody by the investigating officer during a criminal case, Westport Police Station case number 84 of 2024. The mother of the 2 minor children were passed away during an allegedly fight with the in-laws of the deceased mother. And thereafter, after 8 days, that is 8th of June 2024, during an investigation, the investigating officer took the child from the petitioner, who is the next guardian of the minor children, that is paternal uncle from the blood relationship. And till date, the whereabouts of the minor children is not been disclosed, Lordship. We have made
Appearing for
State.
then who are the parents of the child?
the parents of the child has been passed away, Lordship. The father previously and the mother later. And Lordship, shockingly, the no objection letter was obtained from one relative uncle who is namely Uttam Kumar Shah, but not from the petitioner, Lordship.
Now the petitioner is the uncle of the lady.
Of the
mother.
minor children, minor children. The elder brother of the deceased father of the minor children, Lordship. Elder brother of the deceased father of the minor children.
I see.
So he is
Uncle. But then this is now it has been must be with the child welfare committee.
But Lordship, the whereabouts must be disclosed with the petitioner. They have not made any proper inquiry. They have not sent any notice to the petitioner that your child has been taken under our custody. That is not proper.
Milord, as submitted, Milord, the father of the children died in April 2024 in Bihar. The mother of the children were killed by the in-laws. A specific case has been, Milord, she was pushed before a truck, run over, died. Pushed over by the accused in this case are the younger brother of the petitioner. The younger brother of the petitioner, who is also, of course, the brother of the deceased father of the children. The mother of the petitioner, who is the grandmother of the children, and the aunt of the children, who is also the sister of the petitioner and the deceased father also. So, my lord, these three were accused. And my lord,
this person was also accused.
No, this person was not accused. In fact, he was not in the locale when this problem happened.
Very good. Then,
so the brother of the petitioner and the mother of the petitioner were taken into custody, produced before court. Later on, they obtained bail. And the sister of the petitioner, my lord, went absconding, and she was also in the advanced stage of pregnancy. The petitioner was not available. Admittedly, he has admitted in the writ petition also, he was not there in the locale. Under these circumstances, the children's custody, my lord, the absconding sister's husband took the children in his custody. temporarily.
Why absconding sister? Oh,
She was also
she
an
has not
accused.
arrested.
She was not arrested and she was also in advanced stage of
Very
pregnancy.
good.
That is why, my lord. So, my lord, her husband took the children into custody. And, my lord, thereafter, soon thereafter, my lord, the husband, who is the also the uncle
Hmm.
in law, came to the police station, and, my lord, on 8th of June 2025, he said that it was not being possible for him to look after or care for the children anymore. He had taken care of them for some time. So, my lord, the police did the, my lord, obvious thing, my lord, he asked that statement in written, which has been given to the police. On that day itself, the police took produced the my lord, children before the Child Welfare Committee. On the, my lord, orders of the Child Welfare Committee, the children were sent to home. And, my lord, after lodging of this petition, my lord, the police has obtained information from the Child Welfare Commission, and they say that the children were later, my lord, declared free for adoption, and presently the children have gone for adoption. That is my report, my lord. I see the, my lord, report of the Child Welfare Commission also. I have copies if your lordship would want to peruse.
Now, the child has been given to the prospective
Yes.
given in adoption.
Yes. Child have gone for adoption. That is what it has written.
But lordship, this in no objection letter was
And, my lord, this petitioner was, my lord, for his business or for, my lord, other occupation was not there. He came on later. And, my lord, he did not have the, my lord, the custody of the children at any point of time. The uncle had the custody, who came and submitted before the police that he cannot uh, care for the child anymore. So at that moment, the children became juvenile in need of care and protection. Following procedure, my lord, they were put up before CWC, and there are orders of CWC by which they were placed in home and then sent for adoption, my lord. So they are not being held, were not being held at any point of time, my lord, illegally.
When did he make the first representation?
Yes, my lord. The uncle who came, the uncle.
Of June.
Yes, 8th of June is the date when he came to the police station and said that he cannot take care of the children.
This is Uttam came and said.
Yes, I'll check.
lordship, kindly come to page number
Uttam
24.
Kumar. Yes.
We will come back to you. Don't be impatient. Now this page উত্তম হচ্ছে সাগরের ভাই
Oh, not the brother.
সাগর Ramshankar and Sonjit. Who expired? Ramshankar expired.
Ramshankar expired.
Yes.
Who's Uttam?
Uttam is the uncle-in-law.
Uncle-in-law. Own husband.
My lord, Uttam Kumar Shaw, under whose custody the children were there, is the husband of the accused Sunita Shaw. Yes.
Father's sister.
Father's sister. Kishe Moshai, Uttam Shaw.
Now he Uttam made a representation.
Yes. On 8th of June.
On 8th of June.
Yes.
Saying that I can no longer keep custody.
Yes.
Now then what? Then when did Sagor come in the picture? This Sagor.
Yes.
He has come directly to High Court.
Lordship,
For the purpose of the children, yes.
Learned Council is saying that Uttam Kumar.
Just 1 second. সঞ্জিতটাকে
একটা ভাই, ছোট ভাই। 3 ভাই ছিল, মাঝখানেরটা গেছে।
Yes, sir.
Lordship, in a no objection letter, whether it is really mentioned that Uttam Kumar Shah at any point of paragraph is saying that he was not in a position to maintain the children. Page number 24, Lordship. Annexure P4.
25. 24. Yes. Is to inform you that Uttam was in his custody since their birth.
Yes.
So I handed over to the head of government home.
Lordship, kindly come to the signature point just below
So
the
Uttam
just below
is the uh,
even Lordship. This is not the handwriting of the Uttam Kumar Shah.
Yes. Has that been
Just
repeated?
Uttam is the uncle-in-law.
uncle-in-law,
Uncle-in-law. Yes.
and that letter is also not
Just a moment. Uncle-in-law of
the minor children. The
uncle-in-law of
Minor children.
minor child.
minor children.
Husband of one of the accused.
Yes.
Yes.
Yes, sir. Yes, sir.
And Lordship, kindly see the signature of the
If you are interested, you go to the CWC.
Yes.
We will give you that liberty. But in habeas corpus, we cannot interfere. If you are this is not his signature, illegally done.
I understood,
etc.
Lordship,
All
but the
these you have
proper inquiry was also not made. The petitioner was present at the time of handing over the child. The investigating officer only told come along with the child.
Sir,
And
you are the uncle-in-law. Mother has died, father.
but the paternal uncle was there, Lordship.
Uttam has not come to us.
But there is another aspect of the matter also, since my lord, it has been said that he is the uncle, there was the maternal uncle, he is the immediate uncle. My lord, this uncle and my lord, other accused, everybody stays in a single home, my lord. So I could not, my lord, place the child with them also.
No,
Question did not, my lord, fall for me to consider.
Because that document by which you have
Yes.
given it to.
This is the report and my lord, annex documents are also there. I'll hand it over, my lord. আবার কেন দিয়েছি দিয়ে দিন একটু।
No, no, ठीक है. Where is the document, Mr. Bose?
My lord, the document, my lord, of handing over your lordship has seen. My lord will kindly see the last page of the compilation, which is the, my lord, report obtained from the Child Welfare Committee.
The present habeas corpus
দিয়ে দেওয়া হয়েছে, দিয়ে দিচ্ছি।
না, ওটা বাদ দিয়ে দিয়েছে, রিপোর্টটাও ফেরত দিয়ে দিতে বলে। না, Mr. Bose, we will, while correcting the order, we may require
Yes,
those.
I can keep it with your lordships for
ফেরত দিয়ে দাও।
I am for the state.
Firstly, this matter was filed on 11th September. This matter was filed on 11th September, and the copy was served on sent by India Post on 13th. But till today, two private respondent have not received the letter. The copy are still in Baripur.
Now, what is the case, sir?
কেসটা বলো।
The custody matter? Custody? Tell us what is the matter.
The marriage between the petitioner and one Sanjay Sen was solemnized on 26th February 2014, according to Hindu Marriage Act. And on 12th January 2017, a male baby was born. In page number 20, the birth certificate is there.
And this,
Number 20. This is same.
you are having two children?
Yes.
Two children.
This is the first child. Then
First
the
child, what is the second child is Raghav. Who was the first child?
first
Srijit. Srijit.
Srijit Sen.
Acha, ঠিক আছে. Then what happened?
Then in 2020, 24th June, the husband of the petitioner died.
Yes.
Page number 21, death certificate is there. Page number 21. Sanjay Sen, 24th June. Page number 21.
Yes, then what happened? You lodged a complaint.
No. Then during during that, when the husband of the petitioner died, on that time the petitioner was pregnant for the second time. And after her husband's death, his in-laws, respondent number 7 and 8, asked him to suggested him to deliver the second child at the paternal home of the petitioner. And after that, 2 to 3 days in a week, that said child stayed with the mother, that is the petitioner, and 3 to 4 days in a week with respondent number 7 and 8. This was the
Srijit.
the first child.
And the second child had all along been with
Second
you.
child with
Then what happened?
first child, I have.
Acha, then what happened? Then what happened?
I'm telling.
When did you leave your matrimonial house? When were you forced?
After the death of my husband. After the death of my husband, I was second time pregnant. And
Oh, how many times you'll repeat, sir? We heard that. When did you leave your matrimonial house?
after the death of my husband.
That is on 24th of June 2020. Very good. Then what happened?
Then my in-laws suggested me to deliver the second child at my paternal home. And
Then now what is the problem?
পরে কি হয়েছে জজ সাহেব জিজ্ঞেস করছেন কি জন্য এসছো
You have not read the brief
no,
also.
I have wrote myself.
Eh?
petitioner
you
then,
lodged a written complaint on 2nd of June.
uh, from 2025, respondent number 7 and 8 started to prevent me to meet with my elder son. I only get chances to meet with him at the time of tiffin break of his school. And on 26th May,
The learned
2025,
advocate appearing for the petitioner
The petitioner is the grandmother, and my lord, his grandson was my lord, taken away by respondent number 6 for promising to give a work in Telangana. He went there in 24th June 2025. There up to 29, my lord, we have contact. I have contact with my.
Sorry, we didn't follow you. What you are saying?
Well, my grandson is taken away by respondent number 6 on a lieu of giving a work in Telangana. He worked. He was taken away up on 24th June 2025 up to 29. My lord, we have a contract with him. Thereafter, my lord, we cannot contact it. Then I contacted that person who has taken away. He is not taking my phone. Thereafter, I made a complaint before the police authority, a local police authority. The police authority, my lord, registered a case of 363, 365, my lord, kidnapping. My lord, till date, my lord, that person is not arrested, and my grandson is not, my lord, recovered. I am in.
What is the age of your grandson?
18.
16 years, my lord.
Minor?
Yes.
No, 18 এখানে লেখা রয়েছে।
No, no.
16 লেখা আছে petition এ।
Minor, no.
So why
Well,
did you hand over to Anuj?
Well, they have, my lord.
Oh, they have said and you have handed over.
That's 16.
Well, kindly see, my lord.
You yourself send your grandson. Where are the parents of the
Well,
Suraj?
they died.
Both died. So your grand.
Well, kindly see.
The place of occurrence, Milord, is in Telangana. Milord, we have lodged a 0 FIR, and Milord, our Milord direct.
Why Telangana?
Milord, because the son went there. Milord, he was grandson, Milord. Paragraph 4, my lord, kindly see.
But she resides here, na?
She resides here.
So her complaint ought to have been registered by the police.
My lord,
That is registered.
that is registered, my lord.
Where?
My lord, kindly come to page 18. Petition to manage.
80.
Police has registered the case against that private respondent 365, 360. But my lord, my grandson is not recovered. That is my lord.
তেলেঙ্গানা থেকে মিসিং হয়েছে বলে we have already sent it to Telangana. The difficulty is not the boy is missing from Telangana. We have lodged a zero FIR. Our Director General of Police has forwarded request of taking appropriate steps. See, we regularly we are contacting with the concerned
So,
police station.
why you are not contacting this Onuj?
He is not arrested.
This Ontu.
Respondent number
You have not arrested Ontu.
May I speak to the concerned officer and come back before Lordship? She's also in Telangana.
You lodged the complaint when?
my lord, in 37,
30th July.
30th July 2025. So it's page 18, my lord. That is the FIR.
আমি যদি চলে গেলাম কিছু করে বাইরে চলে গেলাম তুমি আমাকে ধরে নিয়ে চলে আসবে না
Specific allegation against that person, but he was not arrested.
Suddenly see that the person is.
No, I've seen. I was talking to my junior on that, my lord, that we need to take into action again, take action against this person. Trace out this person at least. 10 days time, I will kindly allow us to come back, fellows.
Mr. Learned advocate appearing for the eight.
Lord, I appear for the state.
is for the petitioner.
They will probably not appear in this case.
Why? Why?
My lord, they had alleged, my lord, that their girl child who is 19 years old,
Hmm.
my lord, was abducted. FIR was registered. Later on, the girl abducted allegedly was recovered, taken to the court, my lord. Before the magistrate, she only recorded her statement that she does not wish to live with her parents since her parents are forcing her to marry, and she expressly told the learned judge that she wishes to stay at a relative's place. Upon that, my lord, an order was passed by the learned judge. She was taken to that relative's place, and my lord, she is in the custody. She is living with the my lord, relative right now. And my lord, final report of mistake of fact in relation to the police station case has already also been intimated to the petitioners. I have all these in my report.
No one appears on behalf of the petitioners, though Mr. Bose, learned
Affidavit of service.
Okay. And this is my affidavit of service. That the petitioner is a father. Well, the three daughters of the petitioner were one evening being scolded by his wife, that is their mother, for not studying well. They were made to stand outside the house, outside their room.
three children.
Three girl children, three daughters. Well, the neighbors, the neighbor, well, complained to the police that we were misbehaving with the child, with the children, and my lord, we have also tortured and assaulted the children. The specific case was started. My lord, the three children were also picked up by the police, were handed over to the CWC. My lord, the PS case was started under bailable sections. We surrendered and we got bail, the petitioner and his wife.
You are the neighbors.
My lord, I am the father.
Oh, you obtained bill. Oh,
The
neighbors
neighbor
complained.
complained that I have, my lord, scolded the daughter. I am not taking care.
Then what happened?
Yes, ma'am. Now, since then, the three children, the three daughters are, my lord, with the CWC. My lord, the daughters are writing letters to me that they want to come back. My lord, I have contacted with the police officer that you have taken the girl to the CWC. Last whereabout of the girls were known to be in one of the rehabilitation center, that too in November 2023. Since thereafter, my lord, since we are not getting any news of the children, my lord, the daughters have written their letters to us.
To go to the CWC.
My lord, I have made representation to the CWC. My lord, I do not have a supplementary affidavit. It has been given. My lord,
When did you make that representation?
my lord, 24th of September 2025. Before that, I have made representation before the police authorities.
More or less, my lord, the facts, I am one with the facts. Only one addition is, my lord, the petitioners have both, petitioner and his wife have been charge sheeted. And my lord, the girls are, according to my report, are in the rehabilitation center, my lord. That is all. And my lord, another thing, they say that letters have been written. My report says that the letters, my lord, are questionable, my lord.
Now then, why they will not get back custody?
That is up to, my lord, CWC, my lord. Since, my lord, I have
the provision. That
Section 97 of the JJ Act.
What does it say?
Well, at that, after assessing the mental health and after questioning the child, well, at the child in question, well, at the CWC can return the child to the parent, well, to the person who applies for.
Hmm, 97.
Yes.
So when did you give those representations?
My lord, on 24th of September 2025, my lord, I have not prepared the supplementary affidavit.
তোমার কাছে আসার পরে representation
My lord, after
Hmm.
filing this return. Before that, I have made it before.
করেছেন এক্ষুনি হাইকোর্টে এসেছেন
My lord, before that, I have made a representation to the police authorities. My lord, that is
Hardly
that
do anything.
we will say that they are not in illegal custody, and we will say that this habeas corpus no interference is called for. You would be at liberty to take steps before the child welfare.
And my lord, if such steps are being taken, my lord, the child welfare committee to release the child in our favor, my lord.
In accordance with law,
Section 97.
in accordance with law, the
It will place on record.
present
My
petition
lord,
has
only one interference. My lord, since I have made a representation on 24th of September,
no, we will say we are not interfering, and we will say that you would be free to approach the CWC.
already the
Approach.
We will record your contention as
Yes,
regards section
yes.
97. We will give you that liberty and dispose of the matter.
They will only face difficulty because they are the accused. That is all.
My lord, I have.
Milord may say,
Mr. Bose,
Yes.
if I strike my child, I do not lose custody of
no, I
my
don't
child.
stand in the way of Milord. They are taking custody.
If they have made a mistake also that they are saying,
Up to them. Milord, child being separated from their
And my-
parents is the worst thing in the world.
yes,
My lord, the neighbor does not have a child, which is why they were, my lord, envious to us and made this complaint.
is your was your envy to that extent that you will not serve copies upon them?
My lord,
They have not
since
been-
they are, my lord, since the neighbor did not written.
Mr. Choko, the present writ petition has been preferred primarily File a supplementary
It
affidavit.
is supplementary affidavit.
Let's a supplementary.
I am for the petitioner, madam.
I'm for the private respondent.
Service. The petitioners.
Mr. Kormokar, you are for whom?
I'm for the respondent number 7, 8, 9, and 10.
4 respondents. It's raining outside.
Since long.
The petitioner's daughter, my lord, contacted by the private respondent on and from 12th August 2025. Thereafter, my lord, the 14th August, my lord, I made a complaint before the police authority, and police, my lord, I registered a case against the private respondent.
7, 8, 9, and 10. So they are your in-laws.
No, 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 no.
Then who are they?
They are the neighbors, my lord.
Neighbors. They took away the child.
My lord.
You are a married lady. Your husband.
My daughter, I am the mother of the.
Oh, you are the mother.
My lord.
Then what happened? Where is your complaint?
But fire, my lord, it is 13, my lord.
Then they lodged. They started investigation.
They registered a case, my lord. But till date, the recovery was.
The child is minor. Or
yes, minor. 15 years.
Child is daughter.
Daughter, my lord.
How many years?
15 years, 8 months.
Love relationship. History of
Olivier.
Mr. Kormokar.
My instruction is this.
In the meantime,
We are the parents of the boy. That boy who enticed the allegation is they enticed the girl. We are the parents, uncle, and another brother.
Then where is the girl?
The boy, there's an affair between the boy and girl. Both the family knew incident. So my instruction is this: certainly the father of the girl is not willing to give marriage with the parent, that boy. Thereafter, they tried to give her marriage with another person. Then the boy and girl eloped, and the boy did not get any connection with this father and other members of the family.
What more can you submit? That will be your submission. I don't know where my son is.
Yes. And in this case, my lord, in respect of the two accused, notice was served under section 35. They complied. Thereafter, this voluntarily surrendered and granted bail.
Who?
Your lordship, anything? Just
Yes, Mr. Bose, what happened?
Lord, in this case, my lord, the police has not been able to trace the victim girl or the offender. Till now, they have submitted one report and another report has been sent to me today also. Lord, they have not been able to trace them now.
To apply your.
We'll have to do that only. Next step.
What is the age?
15 years, 8 months.
Oh, 15.
But
Had it been a borderline case, he would have waited for that period, come and surrender.
Yes.
Now it is 15.
Another thing is that, my lord,
not turn up.
another thing is that, my lord, after getting the bail, my lord, the private respondent threatened the petitioner, who is a, my lord, paragraph number 5, page 5 and 18, my lord. I also made a complaint before the police authority, my lord.
That is EBS or কি দরকার EBS
Mr.
My son has been missing since 15. My son has been missing since 15 June 2025. And on 15 June 2025, my son accompanied to one Chandan Das, who is the respondent number 7 herein, for daily wage work to Jalpai. Jalpai is situated at border of Purbo Medinipur and Howrah. Thereafter, he did not return home.
What is the age of your
19, my lord. My lord, I have
lodged a complaint?
My lord, I have also approached the district magistrate whose office also duly forwarded the superintendent
19 years.
My lord.
Who is Chandan Das? The person who came to you and said, send your son.
He is a local contractor, my lord.
The local contractor, Yeshwanand number 7. Daily wages, he had already exhibited inclination to be engaged to daily work. That is why he
Yes, Mr.
came to me and
My lord, all required steps under the law has been taken.
not recovered.
Kindly see the report of the police.
He is aged 19 years, left for job under Mr. Misro's client, who is a contractor of railway. Thereafter, he is missing therefrom.
You have questioned Mr. Misro's client? Have
Yes,
you questioned?
yes, every, there is no allegation against him.
No allegation. Then why party? Why you have made him a party?
Allegation. He is the main suspect. Kindly.
Not suspect. He is appearing. He's not absconding. He's
Pardon,
there
my
to
lord.
cooperate.
I had been
with
called
the
on, I had
investigation.
appeared,
Pardon, my
I
lord.
had been
Lord,
interviewed.
kindly see my representations. Page 20 onwards. Everywhere I have written that he accompanied to Chandan Das and
That is true, but then allegation is not there. My lord, annexure A to the report kindly.
last seen with the Chandan Das. And one more thing, my lord, later on 14 July, the eyewitnesses reported that my son has been seen in a naked and distressed condition.
Distressful condition.
My lord.
Where?
Where-
Page 22. Page
At
22.
where, my lord, that was seen by the eyewitnesses. But I have also made searches there, but I have not found him.
Where was our working place?
Jalpai.
Jalpai, the border of Purbo Mednipur and Howrah.
It is in Bagnan.
Is he suffering from any problem? Ailments? Is he suffering from any?
No.
Then why he is not? What can be the reason? Mister, they make an endeavor.
We are taking, kindly see paragraph 3 onwards of the report. All steps are taken as contemplated.
May I have a copy?
What is your name, madam?
Jordan.
My lord,
I am for the petitioner lordship. So, this is an application of habeas corpus. Lordship, here, lordship, what has happened? Lordship, the police authorities has abducted a love interest of a petitioner number 1. Now, yes,
Police authority
has abducted a girl with whom the petitioner number 1 was in a love relationship. They were going to marry each other.
Who is number 2?
Number 2 is the father of the petitioner number 1. He has been detained illegally by the police authorities. May I just state the facts, lordship, what has happened? Lordship, on 2nd of October, what has happened? The petitioner number 1 and the girl accompanied to get married.
What is the age of the girl?
19 years. 19 years. Both out of their own consent want to marry. Now they went to marriage at the way of the marriage registrar. The marriage was not been completed. On the verge of getting marriage, the petitioner number 2 was called on to the police station and was forced to produce the petitioner number 1 and the girl to come to the police station. And it was assurance was given that if the girl comes and tells that out of her own will she went, then the police authorities will let go and take appropriate steps in accordance with law. So in that event, the girl and the petitioner number 1 came to the police station. Upon coming to the police station, the girl was taken inside the police station, and the petitioner number 1 and the 2 was told to leave the police station with immediate effect, or else any criminal actions will be taken. Then what happened? Then I lodged an habeas corpus application. After getting the summons, they produced the girl before the magistrate. After 10 days, in these 10 days, the girl did not have any.
Then what happened?
Then what happened? Then, lordship, after the recording of the statement, the girl was released.
Released to whom?
To the mother.
So then what is
the mother lodged? It was represented that the mother lodged a abduction case. Now what happened? Subsequently, after passing of this order, the girl again came to us, to the petitioner number 1, out of her own will. Now they want to get married, and the local and the police authorities are threatening them.
Police authority
are threatening them at the time when the girl was taken into the police station. The police authorities, specifically the main and the agent of the respondent number 4, who happens to be the inspector in charge of the police station, they continue.
What is the name of the boy with whom you are having love relationship? Your daughter is having love relationship.
I am the
your daughter.
No. He is the appellant is the petitioner is not the father or
Merup Sheikh. Merup Sheikh is the person with whom the girl went away.
Yes, he is the petitioner in this case.
So then what prayer you have made in this petition?
I have made the prayer to as on date, lordship, my prayer is very limited. The both want to get married, and the police authority.
So the High Court will direct that solemnize the marriage?
No, lordship, that is not the question. Police shall not disturb their marriage.
A case of kidnapping has been started against him. This is just a way to circumvent the legal process.
No, the girl was handed over.
And handed over to the mother. Initially, the girl was rescued.
Now, where is the girl's statement that she is willing to go with the?
The girl is here in the.
Abar kotha bole.
I believe report was furnished to your lordships in the vacation bench. So if not, my lord, I have.
Not in vacation.
Is involved in business.
Involved in business?
Business.
What business do you do?
In his father's business. He does a business of bags. Family business. Family business. He has.
Is your business?
Bags of gunny bags.
Gunny bags.
Yes.
So what is the hurry? Why do you want to marry immediately?
But
what is the hurry? Look after your parents.
But I am looking after my parents. I will stay with my parents. From the side of the boy, there is nothing object.
How old is the girl?
19 years. 19 and
20.
at the time of the complaint, she was also major.
What is the name of the girl's father?
Shati Maji,
So Somor Maji.
Somor Maji.
The girl is here and the boy, both of them are.
Complaint was filed by Lakshmi Maji, the mother of the girl.
Do you withdraw the petition or we pass necessary orders?
As on date, Lordship, may I just
There
prefer?
is no illegal detention. When there is no illegal detention, if the police is disturbing you, your avenue is other.
But the question of disturbance, they have a case pending against them, so they have to take legal recourse.
Allegation is, your allegation cannot be gone into by us. Your allegation is that the police have illegally, without handing over the girl to us, the police had illegally is assisting the other party so that the girl can go.
And apart from that, Lordship, may I just make one submission? Lordship, the in the whole procedure, the girl did not have any individual representation. It is the police authorities who has prevented her.
Well, show us one line to that effect that police authorities did. Girl was produced before the magistrate on the basis of the complaint
Of the mother.
of the
After
girl's
10
mother.
days, after getting of the summons of this habeas corpus application, they have.
Forget it. Try to appreciate. This is a habeas corpus petition. Boy and girl are together in court, and you are saying that they are being illegally detained.
They have done.
Withdraw the petition.
Yes.
Try to sort out things. Everything does not happen by force. You are having a problem in your matrimonial relations.
Yes.
No, they are not
If-
married yet.
Yeah.
They are not married yet.
Your so love relations.
Yes.
You are saying that the police is standing in the way.
Yes.
If you are an adult person, marriage means negotiation. Marriage does not mean that you rob the girl or you rob the boy. It's a sweet relationship. Two families have to come together. Everything cannot be brought to the court. You are having parents. You are 19 years. You are also, you are 23 years. You are an adult person.
Yes.
If the girl, the police has intervened, why? Because there was a complaint. The girl was produced before the magistrate. That is your own version. It is not that have you made the mother of the girl a party or family members?
After filing of this writ petition, we have came to know that a specific case has been started at the submission of the state.
You don't know your the person with you are having a love affair. You don't know the names of the parents of that girl.
No, my lord, I know, Lordship, that is not.
কোথায় দিয়েছো?
That after 10 days she was produced.
Where is that she was produced before the man?
10 days. After 10 days.
24 hours.
সেটা দেখা after 10 days he প্রডিউস করেছে
তো পরে জানতে পেরেছি ফাইল করার পর।
সাথে স্বইচ্ছায় বাড়ি করছে। So you intimated the police authorities. That is what she has said in 164. Mr. Show that last line.
ওর বাড়ি থেকে খবর দেয়, তারপর পুলিশ আমাকে ফিরিয়ে আনে, মানে তোমার ক্লায়েন্টের বাড়ি থেকে পুলিশকে, তারপর পুলিশ ওকে ফিরিয়ে আনে। 164, 183 বিএনএ ম্যাজিস্ট্রেটের কাছে। My lord, we had returned, the police had returned to the mother upon a declaration by the girl herself that I have no objection to return to the mother.
No, where is that line?
Kindly, there is another declaration in subsequent pages. Subsequent pages. May I find it for you? No, my lord, this is a declaration by the mother that আমি সুস্থ শরীরে বাড়ি নিয়ে যাচ্ছি, মেয়েকে বাড়ি নিয়ে যাচ্ছি। It's a declaration by the mother.
This was on 13th October 2025. আমি সাথী মাঝি না মায়ের সাথে বাড়ি যাচ্ছি, কারণ কি কোনো that is also here.
My lord, I believe. My lord, kindly excuse me, my lord, I have only one copy, my lord. I am told that it was handed over to the bench during the vacation bench. But maybe.
Even if the girl, the detention, may I just say this, the detention of the petitioner number 2, they have not justified. She was detained for the overnight in the police station, and as far as the girl is concerned, she was produced before the magistrate after 10 days. That is the illegality of the act of the police
But you
authority.
take steps. If you are aggrieved thereby, your forum is open to you.
And my lord, the detention of the petitioner number 2, they have not justified.
What detention, sir?
Illegally detention, she was.
Wait, where have you stated illegal detention? Which paragraph you have stated? Petitioner, who is petitioner number 2?
The father of the petitioner number 1.
Who affirmed the affidavit?
Petitioner number 1.
Yes, where have you stated?
Kindly takes page 4, paragraph 9, last line. Petitioner number 2, he will be detained in the custody. This is just an allegation that he may be detained if he comes within the jurisdiction. And the next page also.
That is after the production of the girl.
They were restrained to enter inside.
But the girl is living with her parents and the parents are residing at such and such place. And this is not a case of illegal detention. You know about the whereabouts of the girl, that is sufficient.
That I have come to know after the filing of this case, from the submission of the state, I have.
Then you withdraw the petition. She is in court, you withdraw the petition then. What right you have to claim the possession of this lady?
Sir, I am not claiming
So
the
if you don't have any right, you are seeking habeas corpus. That she is we could have understood that she was your wife. Marriage had been solemnized.
Yes.
Then if the police had forcibly taken away and handed over the parents, then we could have considered. Try to appreciate.
Yes, Lordship.
Every drop of the hat, you cannot come to High Court like this. Be happy that we are not imposing costs upon you. You understood what is the problem. You are a person who is having a relationship with a person.
Yes.
You are having a relationship. That relationship has not culminated into a legal relationship. Today also you don't know whether the girl after this episode will marry you. It is only after marriage then you can claim that my wife is not being allowed to reside with me though I have been married. Do you withdraw or we dismiss the present?
I will withdraw this application.
See, we don't want to embarrass you. Think about your status and then make the submission. You're a junior advocate.
Yes.
You're a junior advocate. We don't want to embarrass you. Once you say that I am withdrawing, that has to be instruction of your client who is present here.
Yes.
Tomorrow you can face a plea that why did you say withdrawal of the petition? So we are giving the reasons and we are disposing of your. The present petition has been
Well, even till today, my lord, I mentioned this matter, my lord, upon granting leave, my lord, the memo of appeal has been filed. My lord has been, your lordship, you are pleased to fix this matter today.
Which one?
1919. I kindly take up this matter, my lord, the Friday at the top, my lord, otherwise, my lord,
item number
19. I think, my lord, the 2 p.m., my lord, another matter has.
This is এটা ভুল করছি। আমি তো 39 দাগিয়েছি হইবে তো
Not today.
Honda.
19.
19.
Yes.
Other side.
Yes. Like not others. Yeah.
এই
Full service
19 থেকে শুক্রবার দিনকে অ্যাপ্লিকেশন হু ইজ ইওর আদার সাইড
My
Civil Service Commission. Konokiran Bandyopadhyay. He is engaged in another court.
we are keeping it on Friday, it will appear fairly at the top. Ask your advocate to be here.
Okay. Thank you.
19 নম্বর অলোক এটাকে ওই এর আগে দিয়ে দেন। একটা
Taken up. Because those are assigned matters.
If that continues, we will not be taking.
চার্জশিটটা নাম্বার 104 দেখি এটাই যেরকম
Yes, Mr.
Now, Milord, maybe at the risk of repetition, I had probably placed, Milord, the report which was filed by the S. Basudha and Company. If I am not wrong, then we'll just. Yes.
Which was quoted there.
Yes. Now, Milord, I am placing, Milord, the entire. No, I had placed, Milord, the entire affidavit of Basudha Chaudhary, which was.
As regards the TET conducting the
TET and
S. Basu and Company conducted the TET.
TET and also, Milord, the selection process. Both TET and, Milord, the selection process. Not only.
Which page you are?
Milord, kindly come to Milord. The report.
Tell us from the reach petition that report has been annexed.
Yes. No, that was a part. In the report, there is a part of it. Not I referred to. By the way, I was not trying to place the original affidavit which was filed before the court. Some excerpts were given in the reach petition. There was the original affidavit not.
If you can curtail it down to this, otherwise we have to take another bunch
No.
of records. Mr.
Lordship did not. Not that is there already before your lordship. You are spacing with the relevant paragraphs. কোন binding আছে বলো? Yes.
Not read petition, not opposition, not reply, nothing.
Mr. Bandyopadhyay, we have. I have anything. Just we will hear. He has almost finished.
That I again will not repeat that this is a constitutional court. Court has every right to see without the matters which are placed before the court in any proceedings. And this has been referred to particularly. Now, instead of not placing the portion of it, I am placing the entire affidavit, the relevant portion of it.
Page?
But this is paragraph 6 of the said affidavit.
At which page of the compilation?
The first document is the affidavit.
Oh.
The affidavit by Ms. Kaushik Maji.
Yes, yes.
Page number 2. Page number 2.
Paragraph 6.
Where is that? What is the page number of that extract which was annexed to this final binding?
Page 221.
Page 221.
Maybe a subject copy,
Yes. Last option দিয়েছি। ওদেরই দেওয়া, ওদেরই দেওয়া।
Everything has been served.
No, sir.
Soft copy দিয়েছে প্রত্যেককে।
Mr. Bishas, don't worry. We shall show it to you. The document we shall show you. Yes.
Rakesh Mondol.
Which page you want to show, Mr. Bhattacharya?
Lord, I am referring, Lord.
From paragraph internal page 7, it is there in the combined in the.
Yes, but Lord, the paragraph 6 and onwards, Lord, the relevant portions of taking the responsibility that has to be placed.
That you have showed us. Paragraph 6 onwards has been.
Not the entirety, not the entirety. But দুশো একুশটা বার করো।
You want to show us paragraphs?
26টা ছিল মূল ভলিউমে, আমরা গোটাটা দেখাচ্ছি।
Lord, is only Lord the paragraph 26 was quoted there.
Yes. Yes.
Lord, may I just read out for your lordship's consideration? Lord, these are relevant portions, which is because my basic challenge is that this is the institutional corruption. And institutional corruption originated from the day one when you have selected the agency for doing all this exercise, which was supposed to be done by the statutory authorities. And this engagement of private agency in violation of the law voids everything, and that's a settled law decided by this court in other proceedings.
So why you are saying, this Messrs. S. Basu conducted the interview also, aptitude also? Why you are saying that?
That is their own affidavit. That's why I'm not placing this.
You yourself, board, they themselves produce the list of interviewers that the court checked up. 165 questions were put. Nowhere any partner or any entity of S. Basu was called for by the court.
No, my lord, then court wanted them to file an affidavit disclosing the facts. This is the affidavit. This affidavit, my lord, is pursuant to direction of the court.
But this has not, we did not find, subject to correction, reference to this affidavit in the judgment.
May not be. Lordship is
just we are expressing this.
May not be. But my lord,
Your
when
argument is otherwise. We just
when the my lord, the materials are before the court,
all right.
in Mahamad submission, my lord, court will not be my lord, invited to not to look into that.
Which paragraph you are
My
showing?
lord, 2-3 paragraphs, my lord. Kindly come to me, lord. Paragraph 6 of the said affidavit. I state in or about the month of February 2014, the president of the West Bengal Primary Board asked Mr. Gautam Mukherjee, the partner of Basura Company, to give a quotation. Here, entire thing, my lord, originates. I ask you, please give a quotation. And then entire thing proceeded. For the work of printing and delivery of OMR sheet and processing of result of candidates appearing at the Teachers Eligibility Test 2014.
Yes.
Then kindly come to paragraph 9. I state that as per the direction of the West Bengal Board of Primary Education, Basura and Company complied the order mentioned in the letter 10th of February 2014. Then paragraph 11. I state that West Bengal Board of Primary Education sent Messrs. Basura and Company some guidelines to prepare the result as per their guidelines. Publish the result on
No, one copy was in the chamber.
Oh.
Yes, we saw.
Look, kindly come to, now I am at the paragraph 12. At the internal page 4.
You have showed us this.
Yes, I think I have shown that. Yes, therefore, not if I have already shown that, I am not be wasting time repeating that. Therefore, I will not insist upon the principles of law which I want to look at once, that the selection of an outside agency, though law permits, I shall also not show that that permission was also not properly followed. And you have had a prior party in your mind. You did not invite open tender or inviting all competent persons in the field. Please give your quotation so that it can be done impartially. You have chosen one, and that they have followed your instruction to prepare all these things. And what were the scope of work and what they have not discharged? This is very important to me, buttress my argument.
Yes.
Kindly come to page 32. I am not sure whether I had not placed paragraph 15 and 19 onwards with regard to the selection of teachers also.
It has our marking still.
Yes, no. If it is there, I completely rely my lord's memory.
No, you.
I just whether I have skipped or not.
No, you can tell us the paragraph.
Yes. Now I will just relying upon my lord the
You have showed us up to para 11, 15.
Then paragraph, kindly para 14. Now I have placed 12, para 14. I just mentioned the paragraph.
Yes.
Then paragraph 15. I state that the West Bengal Primary Board on 14 September 2016 by a letter asked us to develop an online application portal for the qualified candidates for submission of details and collection of fees and for scrutiny verification of the qualified candidates. This is a very sensitive and gray area to scrutiny and verification of the qualified candidates. Then in paragraph 16, as per the instruction given by the board on 14 September 2016, these are all with regard to selection, not date. Basura and Company by a letter dated so gave a proposal to the West Bengal Board of Primary Education for doing such work. 17, I state that the West Bengal Board of Primary Education notified on its website the link would be created for the qualified candidates to fill up their details by and to pay the required fees for the same. The said notification was published for the vacancy of 41,559 posts, subject to modification. Then Lordship may kindly come to paragraph 19. I state that the West Bengal Board of Primary Education directed Basura and Company to provide a scrutiny verification list as per the district-wise, and the same was submitted to the West Bengal Board along with the attendance sheet of the candidates. Therefore, the entire thing is being done by Basura. The scrutiny verification list has provisions for writing of viva marks, aptitude marks, and extracurricular marks by the scrutinizer, along with the remark, if any, against each candidate. Then Lordship may skip over the other paragraphs. Kindly then turn to paragraph 23. I state that as per the requirement of the board, Basura Company updated the same in the data of the candidates and sent to the board a final error list containing errors marked by the system for checking and get it verified with error list provided by the board. I state that the board sent us the updated final error list of the candidates clearing the errors marked by the system. Then 26 is very important. I state that the West Bengal board asked Basura to prepare the initial empanelment list for trained and untrained candidates separately category-wise, medium-wise. Said list was prepared by the company and delivered. List of trained and untrained candidates separately category-wise, medium-wise. The said list was prepared by the company. Kindly note this. List was prepared by the company and delivered to the West Bengal Board of Primary Education on the dates indicated below. Then 27. I state that Basura Company received the request from the board on different dates to prepare an additional panel. The dates are mentioned.
Yes.
Then paragraph 29. I state that Basura Company prepared additional panel lists and submitted to the board on different dates. The additional panel lists were sent through emails, as well as some of them were served upon the board physically. Now, these are the areas which really...
Yes.
Then, Lord, I do not trouble my Lord with this any further, but kindly turn to page 32. Oh, sorry, para 32 is important. Mr. Gautam Mukherjee, a partner of Basura Company, was the senior partner and was also the controlling partner of the firm, and he was functioning as the sole liaisoning officer with the board Said Mukherjee died on 24th November. After his death, there is a difficulty to reach out to the documents which he was having the sole knowledge and possession. Therefore, none of the original documents, as it appears from here, Lord, has been made available to the board. Kindly come to me, Lord. Page 32. Scope of work. I'm just referring to your Lordship to show that who had done this. And page 33.
Yes.
Lord, I am not reading out the whole thing, but this really all the steps for selection. And the important part is page 33, Milord, paragraph 5. Post-interview final panel list. Collection of candidates' data from the qualified candidates list for interview test. Candidate details obtained for extracurricular activities, training details, viva voce, aptitude test. And final calculation of overall marks for each candidate. Preparation of panel for candidates as per rules. Now kindly turn to Milord the rules. This is very important, statutory rules. But I believe, Milord, we have given the compilation of the rules.
Yes, we have that.
Outside agency, they rule 5, no?
Rule 4, 5. Rule 4, sub rule 5.
ওইটা বোধহয়
এমনি
কম্পাইলেশন এখান থেকে দেখে দাও না
ভলিউম 1 এ আছে ভলিউম 1 পেজ নাম্বার 111 এ আছে
আলাদা কম্পাইলেশন নিলে ভালো হয়
আমরা কম্পাইলেশন দিয়েছি এটা ওটা না জাজমেন্টের কম্পাইলেশন রুলস এবং অ্যাক্টের কম্পাইলেশন দিয়েছিল রাতুলদা এরকম এরকম রুল এন্ড অ্যাক্টস কম্পাইলেশন রাতুলদা দিয়ে
রুল এন্ড অ্যাক্ট কম্পাইলেশন
হ্যাঁ রাতুলদা দিয়েছিল
না দিয়ে দাও না
পেজ নাম্বার 111 in volume 1
page
111 volume 1
judgment compilation
no volume 1
volume 1 we have the rules.
There is a rule paper book in paper book
আস্তে উত্তেজিত হওয়ার কিছু নেই
Yes, Mr. Auditor.
Well, kindly come to rule 4 sub rule 5.
Yes.
My lord, please to note, with the prior approval of the state government.
Yes.
Both shall have the following power to lay down modalities, procedures, or guidelines as the case may be. Now, the rule makers were, my lord, very much cautious that every stage there should be check. That's why I say this is with the prior approval of the state government. And in the affidavit, my lord, which I have filed indicates, my lord, I have not found any affidavit by the board or anybody, other agencies to say that yes, they had the prior approval of the state government. If the statutory rules is violated for the purpose of selection, my lord, I don't have to argue. Law is well settled. Everything is void.
Yes.
Then kindly come to, my lord, rule 8. Formation of selection committees, rule 7. Then rule 8, procedure for selection. The selection committee shall make prima facie scrutiny of the duly filled application forms submitted by the candidates having qualifications mentioned in rule 6. And the selection committee method has been defined just the prior rule 7.
Yes.
And procedure of selection is given. Now, my lord, one point I have to clarify, there was subsequent amendment. by which Rule 7 was amended. এটা কোথায় পাওয়া যাবে?
কম্পাইলেশন
পেজটা বলো।
Yes, you tell us the
The Rule 7 was amended.
yes.
ভলিউমে অ্যামেন্ডমেন্ট নেই
By please give us the notification date.
Yes, this is notification dated 23rd of September 2016.
Yes, 23rd September.
Now the amendment was Lord of Rule 7. Rule 7, Lord, I have not placed but referred, which comprises, Lord, the Constitution of Selection Committee. Now this is amended. By amendment, Lord, this is said the board shall constitute the selection committee for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers in primary schools within the jurisdiction of the board. B, in sub-rule 3, for the ward chairman, substitute the words president of the board.
It is substituted by this rule.
Yes, by this amendment. For handy, you should take this. (23rd September) notification number 656.
It is amendment. What shall constitute? What shall constitute selection of the purposes? Right.
Outside agency to
সিলেকশন কমিটির কাজ কখন
জিজ্ঞেস করছি
একদম
Now it is said
Rule 7, selection committee shall normally function for 2 years. Any member of the committee other than the official member may resign. So that is not 3. The amendment is of, my lord, note 7 of sub-rule 3, that is Rule 6. I will kindly come to amendment of Rule 7, next page. In Rule 7, the 3 is the, my lord, the 3rd amendment, and that relates to Rule 7.
board president of the board. এটা হচ্ছে sub-rule 3.
chairman was substituted by president of the board.
Yes. Therefore, initially it was, my lord, by the district chairmen, it should be done district-wise, which was more decentralized. Now it is being made centralized. It comes under the full control of the president of the board. The amendment is very important, very relevant for our purpose.
You point out the amendments with pencil. This is the notification you gave.
It's just
There is an amended rule. This
will help us. These amendments are there inside.
এইটা আমার চেম্বার থেকে এলো, ওটা দাও। না ওটা না, এই যে কাগজটা দাও।
এই রুল গুলো
এই
একেবারে
যে
কম্পাইল করে
কাগজ,
দিচ্ছ না
এই যে, হ্যাঁ,
My lord, here also, my lord, the amended was incorporated and my lord.
আমার চেম্বার থেকে যেটা এলো,
ওইটা, that is an amended.
একসাথে দড়ি দিয়ে বেঁধে আনলাম তো।
এটা নেই তো,
সুব্রত কোথায়?
তাহলে আমরা লিখে নিই সুবিধা হবে।
বললাম যে এখানে যাওয়ার জন্য।
With amendment.
সুব্রতটা কোথায়? আমার চেম্বার থেকে যেটা বেঁধে fought with 100 lawyers, we are only 2%. Have some mercy on us.
The lawsuit has flagged it already.
Yes.
104 it starts. So show us
Rule 7 amendment which Mr. Bhattacharya
Oh,
explained.
thereafter, my lord, just.
That is
Oh,
why
oh,
I opened this page.
I
So that you can make a pencil incorporation about the added amendment.
I understand.
Amendment notification.
Please see whether is that rule 7 the amended rule?
Yes.
Huh?
Yes.
Where is that word president? Chairman will be substituted by
yes.
the word president. Pencil লিখে দে না।
Yes, my lord.
আচ্ছা, এভাবে mark করো। Just give a tick mark.
My lord, my lord.
পেন্সিল দিয়ে কর, পেন করিস না।
Pencil, sir.
President.
কিন্তু পেন্সিল দিলাম, পেন্সিল নেবে না।
Pencil, my lord. I'm doing it pencil.
So you carry pencils also?
এখানে এটাও amendment.
হ্যাঁ, এই তো সবগুলো amendment.
Amended জায়গাগুলো মার্ক করে দাও। এখানে প্রেসিডেন্ট অফ দি বোর্ড আছে, এটাও amendment. চারটা amendment.
Your argument on amendment is that it was brought within the jurisdiction of the chairman. Before it was a decentralized one. This is your argument.
This was decentralized where the respective councils would have done it, the selection
Now it
committee.
has been taken over by the president of the board, who without giving any tender or anything, bought this S. Basu company for treatment. This is your argument.
That's my argument. And that too, my lord, as per the requirement rules, there was no prior sanction of the government. Yes.
Selection committee rule.
Yes.
Therefore, my lord, this violation of rules for the purpose of selection process, my lord, vitiates everything. That's my lord, my fundamental point. It might be, my lord, repeating time and again, and which is fortified and uncontroverted by the affidavit of Basura and Company.
Yes.
Selection committee ওগুলো করবে একবার
দেখে নিয়েছি কি বলেছে প্রশ্ন বুঝে গেছেন কমেন্টটা বুঝে এবার এটাই তো নিজের ওই বোঝাইলা বলছি আমাদের কমেন্টটা ফলো করো জজকে তো আনিয়েছে রাত করে লাভ নেই
They will not leave you, Mr. Bhattacharya.
Don't overhear. To make it very precise and poignant, that these had planned with a corruption in mind, and that corruption ultimately fortified, which has been reflected by the investigation revealed done by CBI in the direction of court. These investigations were done. Now, the last occasion, I had referred to the charge sheet file, and the Honorable Court was pleased to direct me to place the charge sheet in detail, which is filed in court. And we have already given Worship the
No charge sheet.
you have given a bunch. They can total.
Which volume? Which volume? That spiral binding or this?
No. This one. এগুলো লিখে না একটা ফ্ল্যাগ করে দিয়ে দিতে হয়, খুঁজে বেড়াবে নাকি? হয়ে গেলে পরে করে দিয়ে দেবো অ্যাডিসিভ স্টিকার দিয়ে।
Yes, Mr.
Now, my lord, kindly straightway come to page 104. Lord, this is a third charge sheet, supplementary. Well, I would rather invite my lord's kind attention so that nobody can really create any trouble.
104.
102. How this investigation proceeded.
Yes.
The instant case, paragraph 16.1.
Yes.
The instant case was registered on 9th of June 2022 in compliance to the order dated 8th of June 2022 passed by the Honorable Court at Calcutta in WPS so on alleged offences committed by unknown office bearers of West Bengal Primary Board in conducting teachers eligibility test and subsequent selection process of assistant teachers, both.
Yes.
Now then kindly turn to the result of investigation. It starts from page 104. But I will take my lord's leave to place it in detail.
So, Mr. What is it? You said you will show us the relevant portion.
Relevant portion. Well, I am not reading the entire 104 paragraphs, 104 particularly.
Yes, sir.
Page 104, paragraph 17, the result of investigation. In supplementary charge sheet filed in this case on such and such, it was mentioned that in May 2017, a list of 752 unqualified candidates was generated falsely showing them as withheld candidates, whose results were withheld due to submission of inadequate documents. Out of these 752 unqualified and purported withheld candidates, 300 candidates have been appointed as primary teacher. It had been revealed that on 5th of May 2017, accused Partho Sen had sent the list of said 752 withheld candidates from the email of Basurai and Company. On the instruction of late Gautam Mukherjee, who had been holding all these documents which are not now available to anybody. The emails of Manik Bhattacharya, the president of board, and of email of Srimati Bakchi, then secretary. Further investigation revealed that the teachers' eligibility test was held on 11th October 2015 throughout the state of West Bengal. Investigation further revealed that while the appointment process were going on in the year 2017, numerous candidates had written to the board and a few had moved petitions before the Honorable High Court that a particular question number so and so, I'm just skipping over, Okay, very well. Let us place them. Let them be satisfied. Investigation further revealed that while the appointment process was going on, in the year 2017, numerous candidates had written to the board, and a few had moved petitions before the Honorable High Court at a particular question number. In so and so, in Bengali medium paper, had two correct answers, that is options A and B, and only those candidates who had marked option B had been awarded a mark. It has emerged that on 20th November 2017, a resolution passed by the board, very important, that those candidates who had marked option B should also be awarded 1 mark, provided that the candidate should be trained, fell short to qualify 1 mark, have written the exam in Bengali medium and have marked option A, which was also a correct response. It has emerged during investigation that a total 428 candidates fell in this category, and therefore 1 mark should have been awarded to all of them. Investigation has revealed that instead of 428 candidates being declared qualified after the award of 1 mark, board declared a panel of only 270 candidates. Board had thereafter deliberately discriminated by picking or choosing a few candidates and depriving the others. It has further emerged that out of the aforesaid 270 candidates, 264 candidates were appointed as primary teacher. During investigation, it has been revealed that as per the records filled up the candidates, 46 candidates were non-trained, and at the relevant point of time, 9 candidates were those who even after award of 1 mark did not qualify, got the appointment in their respective categories. 2 candidates had appeared in TET 2014 Urdu medium and 1 candidate had marked option B. Therefore, the board, in publishing the panel of 270 candidates, had deliberately accommodated such candidates as mentioned above, who were not entitled to be awarded 0-1 marks as per the resolution of the board itself. It therefore emerges that board had deliberately resorted to subterfuge of awarding 1 mark and had accommodated undeserving candidates at their whims and fancies against extraneous considerations. It has emerged that the resolution was passed by the board in a meeting dated 20th November 2017, which was chaired by Dr. Manik Bhattacharya, the president, and other board members. A note was put up by Manik Bhattacharya to the Principal Secretary, Department of School Education, Government of West Bengal, along with the copy of the resolution and expert opinion for further processing in the ministry. Finally, the note was accorded approval by Parthu Chatterjee, the then Minister of Education, on 22nd November 2017, within 2 days. Accordingly, on 30th November, another resolution was passed by the board that 270 candidates met the aforementioned 4 criteria decided in the resolution dated November 17, and also enclosed the breakup of such number of candidates.
Yes.
And also includes the breakup of such number of candidates. It has emerged, that I'm reading it slowly, that the details of the candidates like roll numbers, name, father's name, etc., have deliberately not been entered in the resolution register, only to avoid detection and keep the entire act of commission discreet. The board has informed that no records, underline this, board has informed that no records regarding interview, aptitude tests, preparation of merit list panels, regarding appointments of candidates under the resolution of the board meetings for awarding 1 marks are available. It has emerged that those 270 candidates were recommended to the respective DPSCs for issuance of appointment letters under the signature of Ratna Chakraborty Akchi Suranso. The investigation has established that 264 candidates were appointed in a grossly irregular manner in pursuance to the criminal conspiracy between Parthu Chatterjee and Manik Bhattacharya under the garb of resolution of the board for award of 0-1 marks to the undeserving candidates, which was approved by Parthu Chatterjee. Next page. Investigation has revealed that much prior to the preparation of the additional panel, of 270 candidates for appointment and email dated so-and-so, along with a list of candidates containing roll number, name, mobile number, etc. of 752 candidates, was sent to email ID of Manik Bhattacharya. Email ID is there, I'm not reading that. The said email, along with the list of 752 candidates, was then forwarded to Probir Banerjee, OSD, to the then Education Minister Partho Chatterjee from the email secretary of board. It was mentioned in the said email that the board is unable to upload the list of so-and-so list to this website due to server problem and requested the MIC to take necessary steps to upload the same. It was further mentioned that the heading of the list will be, quote, list of withheld candidates who are requested to submit particulars at room number so-and-so only on working days. However, the dates of document verification were changed to 11th May 2017 to 16th May 2017 by Manik Bhattacharya, who also informed that those candidates would be called through SMS message for verification of the documents.
Yes.
Then the next page, I'm just pointing out relevant portions. 108.
Yes.
Investigation has revealed, the middle portion, has
Yes,
revealed
yes.
that Partho Chatterjee had given a list of 15 candidates to Probir Banerjee for sending it to Manik Bhattacharya for entering their name for document verification along with 752 withheld candidates, thus making the list 767. Investigators revealed that during the period of so-and-so document verification, the candidates was conducted so-and-so. Well, I'm just not taking the other part, then it has also been revealed, but the concluding line of the paragraph.
Yes.
By the staff who had collected the documents of those candidates that no interview, no interview, viva voce were conducted during that period. After completion of documents verification, a list of 767 candidates containing so-and-so, 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 and the marks obtained, graduation total marks and marks obtained, DLED total marks obtained was prepared in the office of Partho Chatterjee. Who has done this selection? But such gross irregularity really shocks the conscience of court. In other matter, that's the finding of the court also. Now, this is the relevant part I have placed. I am not taking much time of lordship to play the detail. Then third charge.
Second paragraph.
This was the third charge sheet?
No, this is second.
Supplement.
Second supplementary. Then kindly turn to Milord just for it. Page 111. Investigation has revealed that out of 752 candidates, 310 candidates have been appointed. Thus, the investigation established that Partho Chatterjee, the then minister, in criminal conspiracy with Manik Bhattacharya, had facilitated the illegal appointment of aforesaid 310 candidates. During investigation, list of 324 candidates, actual candidates in the said list is 321, along with the roll numbers and names of referral persons. Well, this is interesting. Names of referral persons are also there, who are politically influential, was recovered from the warehouse of secondary school education department located at Bikash Bhavan. Investigation revealed a total of 134 candidates out of 321 have been appointed, which has been confirmed by board.
So referral candidate, political also the referral candidate.
Now then we'll kindly come to the third charge sheet. That is at page 130. Result of investigation. over. It has been last paragraph 7.6, the last line of this paragraph, which has been confirmed by the secretary.
Page 111.
No, 131.
131.
Well, this is the third supplementary charge. Well, I was placing the second, now I am coming to third. 131, paragraph 17.6. Got it? Well,
Yes.
last line. It has been confirmed by the secretary that 10 candidates out of the said list of 85 candidates have been appointed. Investigation has revealed that so and so.
This is the third supplementary charge.
This is third. That 111 was
111 was there.
second.
Yes.
The investigation revealed so and so that were sub-agents of Sujoy Krishna Bhadro. Now, his name is more well circulated in the society now. As per the direct the appointment as primary teacher. Then it has been revealed that accused Kuntal Ghosh had forwarded a list of 35 candidates of SSC that is not already set aside by the court. I am not just referring. Then next paragraph, 17.8. Investigation revealed that accused Kuntal Ghosh had collected about 25 crores from undeserving candidates of primary, upper primary, SLST, 9, 10, 11, and so and so. This 9, 10, 11, 12, Group C, Group D had been set at naught by the Honorable Supreme Court, upholding the judgment of this court. So nothing remains to be done for this primary and upper primary. During the course of investigation, copy of one diary of accused Taposh Mondal was collected, wherein it was reflected that he had delivered 19.47 crores to accused Kuntal Ghosh for appointment of candidates of various examinations. It has further been revealed that Kuntal Ghosh had delivered about 10 to 12 crores to Sujoy Krishna Bhadro for securing appointments of undeserving candidates at the residence of Sujoy Krishna Bhadro at Behala and at the office of the Lifts and Bounds Private Limited, New Alipur, where Sujoy Bhadro used to work as chief operating officer. It has further been revealed that out of the delivered amount of rupees 10 to 12 crores, 5 to 6 crores was delivered by accused Kuntal to accused Sujoy Bhadro towards arranging appointment of primary teachers in presence of Aurobindo, Surojit. Investigation has revealed that accused Shantanu Banerjee was known to the accused Sanjoy Bhadro by virtue of being a member of same political party. That is so and so. I am not mentioning the political party. I don't want to add anything which can create chaos. And had acted as a sub-agent of accused Sujoy Bhadro. It has also been revealed during investigation that accused Shantanu Banerjee had introduced Kuntal to accused Sujoy in pursuance to the criminal conspiracy hatched among them.
Yes.
Then we'll skip 7.9, now come to 17.10. From the said conversation, it has revealed that during the said meeting, accused Kuntal, Shantanu, and Sujoy discussed about the modus operandi of collection of bribe from the undeserving candidates and getting them illegally appointed by manipulating the result and filing a case before the Honorable High Court and getting favorable orders. Lord, some petitions were being filed, kindly direct it to be considered, and the mechanism was adopted. It has illegal appointments were accused by Kuntal, Shantanu, so and so. It has further been revealed from the conversation that there was a rift between Abhishek Banerjee and accused Partho Chatterjee on the issue of illegal appointment. And accused Sujoy Krishna Bhadra was heard saying that Abhishek had demanded 15 crores from the illegal appointment already done. And when Sujoy expressed his inability to collect more money since the candidate has paid 6.50 lakhs each, then Abhishek Banerjee told Sujoy to stop the appointment. These are the investigations. Then 17.12. Investigation has revealed that accused Shantanu had collected bribe 1.39 crores from Gunodhar Khara, ex-panchayat member, Arambagh of so-and-so party for arranging illegal appointment of 26 candidates. Now, how grave it could be, kindly just visualize. Now, see the page 130 is charge. What are the charges?
Charges are required, Mr. Bhattacharya. You will go
No,
through.
not required.
You have showed us the details of the.
So, therefore, these are the facts of corruption vis-a-vis collection of money. According to me, corruption doesn't always mean exchange of money. Corruption has a wide aspect, and I have already placed a judgment. I am not going to deal with that further. But if this is the factual aspect, uncontroverted factual aspect, and the investigation also speaks of appointment of SSC candidates, Group C, Group D, which has been declared void by the Supreme Court, but I repeatedly say this because this would come same. Now, kindly come to me, Lord. Now, Lord, I just hand up to your Lordship, Lord, the matters of record, the list of, my Lord, rank jumping.
No, this you cannot, Mr. Bhattacharya. This is not there. Further documents, Mr. Bhattacharya, you argued chart sheet. It's a document which is there. As regards rank jumping and other allegations, Mr. Bhattacharya, that has been contained whatever in the spiral binding papers.
Yes, there.
So yes, that we will.
No, I am just only adding more examples.
No. You can tell us the pages for your satisfaction that which page it shows rank
That
jumping.
these are all will not reflect in the CAN application, which your Lordship was pleased to admit. Not all, but few. Therefore,
Rank jumping in the spiral binding, rank jumping, do you want to show us any page to that effect?
Miller, I am told Miller, spiral binding really does not reflect this rank jumping issue.
So then, Mr. Bhattacharya, please see the order of the coordinate bench. You allow your application CAN 5 was allowed.
Yes.
Specific rider that further document shall not.
No, I am not. I am only Miller compiling the documents which already disclosed the CAN. But these are not new documents.
No,
For the benefit of the court, I have not compiled which is reflected in the CAN.
In CAN 5?
Yes. Kon 5 আছে?
বিভিন্ন ক্যানে আমরা অ্যাপ্লিকেন্টরা মোর মার্কস পেয়েছি
আমার কথা
ক্যান 5 এ নেই
Mr. You have extensively submitted on that, Mr. Bhattacharya. So on that case,
for whatever the effect might be, kindly please take this note that many petitions are pending. There are definite allegations of rank jumping. Now, I know they are scared of it because this is one of the ground by Supreme Court was supposed to set aside the earlier appointment.
More meritorious candidate বাইরে আছে more meritorious
and the
100 petition
yes. Well, I am told that the CAN 3 was allowed by your Lordship and there she list কোথায় list কোথায় rank jumping
পেজ নাম্বারটা বলতে পেজ
আলাদা লিস্ট করতে বলেছিলাম
পেজ নাম্বারটা আলাদা হয়তো খোলা হয়নি স্যার এক্সেল চার্ট করে দিয়ে পেজ নাম্বারটা বলে দাও পেজ নাম্বার
no but Lord this is below the CAN was admitted by your Lordship paragraph 10 of CAN 3 আচ্ছা আমি বারবার করে বলেছি সেপারেট লিস্ট করো ফ্যামিলি কোনো কথা শুনবে না তো। আরে কেন যাতে কি হবে কোর্ট কি খুঁজবে নাকি
কেন তোমাকে দেবো কেন? ইউ আর নট এ পার্টি, কোর্টকে দেওয়া হয়।
The 19th of May
19th of May
2023.
Can 2 and 3 allowed?
Time jumping কোথায় বলছে টাইম জাম্প এটা একটা ডিফারেন্ট অ্যাপ্লিকেশন আছে এদের মেরিট লিস্ট
Yes, paragraph 10 you are showing.
But paragraph 10 paragraph 11 আমি না তোমাদের নিয়ে পারবো না তোমরা আমরা জীবনে করতে শিখবে না এটা কি
10 11 and
এটা জেনারেল ক্যাটাগরিতে চান্স পেয়েছে টেট ফেল বিভিন্ন অ্যালিগেশন আমার তো ডিফারেন্ট টাইপ অফ অ্যালিগেশন আছে these are the basic allegations of rank jumping and merit violation চাকরি করবে কি করে সাকসেসফুল তো চাকরি না পেয়ে তোমরা পেয়েছো চাকরি পেতে সাকসেসফুল
all right. Thank you, Mr.
But these are the basic issues. Now that I would just refer to your lordship, Lord, the few authorities, the judgments I had already referred to your lordship. I'm just placing the important part. আমার দাগ দেওয়াটা কোথায় আমার দাগ দেওয়াটা কোথায় না আগের বাড়ি যেগুলো সেগুলো দেখাবো
বইগুলো
Now that one extensive argument was made, I was told that how could the Honorable Court procure these documents by exercise of power under 165? That 165 has been dealt with by the other division, which I'm not going to that. But even in spite of, Lord, I can get the documents by illegal means. If the existence of those documents are not disputed, that can be taken into account by the court. This is 1970 volume 2 SCC page 888. Barcode. আমার বই আমার
1970 বইটা
জাজমেন্টের কম্পাইলেশন
দুটো ভলিউমই দিয়ে দিন
দুটো ভলিউমে দেয়া দেওয়া হয়েছে
তারা পুরো মানে
পেজ নাম্বার 339 পর্যন্ত ভলিউম তারপরে
এটা কোথায় তুই পেজ থেকে যাও নি খুলে পাবো কি করে আমি না তোমরা আমার বই বার করো
ভলিউম 1972 এসপিসি 888 পেজ নাম্বার 224 কেন 224 থেকে 237
তোমরা না ছেড়ে দাও 224
1972 এসপিসি 888
You have referred to Standard Chartered Bank, Mohammad Abdullah Azam, as regards deemed pleadings, and as regards deemed pleadings, you referred to
yes, that is
Standard
deemed
Chartered.
pleading that you have referred to.
Yes, and you have also referred to Mohammad Abdullah Azam.
Yes.
And
মগরাজ পাটোদিয়া এটা হচ্ছে মগরাজ পাটোদিয়া
another year, State of Gujarat versus R.A. Mehta, this 2013 volume 3 SCC.
Yes.
Now, over and above that, you want to rely further?
Yes, but your lordship wanted me to give the list of the judgments which I would rely upon today. I had given supplied the
we have
list.
got this one.
This is the bunch of the judgments. If I am not referring all the judgments, I had given a list of judgments which I shall really rely upon.
Where is that list?
Last occasion, this is
Yes, which judgment you are showing? 1970 Supreme Court.
Yes.
1970 volume 2 Supreme Court cases, page 888.
224 number page.
That is, I am told, my lord, page 224 of the compilation.
Triple eight. Which paragraph, Mr. Bhattacharya?
The paragraph, my lord, I just go to
We shall check up, Mr.
So
Vasu.
the
This is
understand-
on the point of recovered by illegal means also.
Yes,
be
can
taken
be.
into-
That's the point. Now, this is Magaraj Patodia versus R.K. Birla, 1972 SCC, page 888. And no interference with the findings when this result of a prudence.
I feel 70
Yes, Mr.
Well, I shall rely upon paragraph 30.
29 and 30.
30, yes. Then next, my lord.
12 volume.
I had cited my lord 2012 volume 5 SCC role of the judges, and I think I had cited that. Now, my lord, I shall cite 2021 volume 16
No,
Supreme
can you give us to 2012 volume 5 SCC the paragraph
paragraph
33,
33, 38, yes.
Then 2021 16 SCC.
Yes, yes, yes.
Yes, this is on the selection. If there is an illegality, selection
Right.
process too.
Right. No, my lord, sympathy that they have continued. 2021 16 SCC, page 217.
Then
Then
1994
1994 4 SCC 164, the same principle.
Achha.
Therefore, my lord, I am not really citing the paragraphs, just referring it to same principle.
Then 2025 SCC online Supreme Court.
This is, my lord, the latest judgment.
This is
This is the judgment, my lord. It went up from this court with regard to SCC.
Boishaki.
Now, my lord, latest, my lord.
Now 22 volume 7 SCC 482, that is derogated to
Same thing, same principle, my lord, which.
yes.
Now, my lord, only lordship probably has, my lord, taken the trouble to go to the judgment of the division bench of a high court with regard to SSC recruitment.
Yes.
I am not troubling with that. And also, my lord, the Supreme Court judgment, my lord, upholding that. That you have also gone into. Therefore, I am not troubling. Therefore, but these are the authorities on which, my lord, I would most humbly submit, my lord, the entire selection should go, and there should be fresh selection from amongst the, my lord, the persons who had qualification then, so that a fair process is followed and
all qualified candidate, all qualified.
the person they should, my lord, there should be proper, my lord, appreciation as per the rules, and let it be done. This is education. I don't have to emphasize on this. This is not, my lord, appointment of
Education and health. You are good.
This is not, my lord, the appointment of a, my lord, the civil volunteer or, my lord, constable. This has a, my lord, huge impact in the society for a long term.
Thank you, Mr. Yes, where is Mr. Dotto? Kishore Dotto. Then you start. You reply on that one. The council.
That since sorry.
Yes.
That since, my lord, this judgment will ultimately govern the field, my lord, many writ petitions are pending. Therefore, your lordship will also please to consider, my lord, whether those writ petitions come under this or not. If the judgment is delivered,
Because we have been said decide these 44 appeals.
very well. But then the
other writ petitions, whatever we hold, it will guide the other appeal. If the selection
therefore, those writ
process
petitions
goes,
remains on their own merit.
yes, that if your
If that
argument
covers
is that
the
we have to set aside the selection process,
then everything goes.
uphold the judgment. Then the prayer made in
Becomes
this writ petition also
infractuous.
Before your lordship, before your lordship,
you will request to the court. Wait.
that the details of the applicants in CAN 2 and CAN 3, that is the roll number, date roll number, may be shared with us.
Yeah.
Details of the
Applicants
that must have been given in the petition.
They are not entitled to get it. I have given it the board.
বোর্ডের
what
কাছ
is
থেকে নিয়ে নেবে
what is
বোর্ডের
your
কাছ থেকে
problem, Mr. Majumdar?
স্যার ক্যানে অ্যানেক্স করা আছে আমি ওদিকে দিতে যাব কেন আমি বোর্ডকে সার্ভ করে যে ডকুমেন্ট ইজ অ্যানেক্সড
We will accept that submission. No, Mr. Majumdar, there is an instance here itself, because in the earlier Monica Das and the other justices, they are all subsequent writ petitions have been filed.
Subsequent recruitment processes.
So what? How does that work?
সাবসিকুয়েন্ট প্রসিডিংস তো হতেই পারে
Mr. Bhattacharya, you do one thing, you ask your junior, so far as 20 can 2 and can 3, sir, how many applicants total are there?
কত তোর candidate? কোথায়
No.
Can 370.
I can
Mr. Shami, you give us two particulars. Give us two particulars. One is their roll number, and the second is whether anybody of them have already got employment
No,
in
not
the
yet.
subsequent procedure.
In can 2 there are
Because if
6
anybody
applicants.
has got employment, he would not be interested. I mean, that's not an issue.
It was filed earlier.
No.
Petitioners have got it. Petitioners have got it.
আমার অ্যাপ্লিকেশনে আমাদের সব ডিটেইলস দেওয়া আছে
Data. How are you getting access to the data? It's a connivance between.
We have requested Mr. Bhattacharya. So far as the roll number, Mr. Bhattacharya kindly
Roll
ask
attendance.
your junior, and secondly, whether they have participated in the subsequent selection process.
Obviously, they have obviously participated, but that
Even
is
if
what-
I have not participated, that does not take.
Probably you are right. I wanted to know. Just
But as per the court's order, I shall be.
yes.
Before your lordship,
এরিয়া ও দিন আমি এক্ষুনি
grant 4 of the
একটু এদিকে
just
চলো।
want to make submission for
No, that is over. You are supporting who?
grant
Mr.
4.
Bhattacharya.
No, grant 4.
Can 4 Mr. Vikas Ranjan Bhattacharya and Deepak Chatterjee is appearing.
He is appearing.
In grant 4, Lord, I am appearing.
ক্যান 3 ওটা ক্যান 3
That was can 3. Can 4,
You are at par with the the appointed candidates.
Lord, I have not been selected. We have challenged, Lord, we have filed.
Priyanka.
Yes,
Common to Priyanka.
common to Priyanka. But our writ petition was pending along with Lord Priyanka Noska's case. Lord, I'll show you, Lordship.
No,
Lord.
then what happened? You're that Priyanka.
Then my writ petition was disposed of in the light of the judgment Lord passed in the Priyanka Noska's case. Now it was pending. Now thereafter, Lord, we had to make an application before the Honorable Division Bench by way of CRAN 4. The CRAN 4 was allowed.
When?
Lord, the order of can your Lordship would get, Lord. No, I ordered today. This was passed on, Lord.
You want to make further
I
submission
just want
over
to
Mr. Bhattacharya
Lord,
has
just Lord, perhaps Lord, whatever I am going to argue, Lord, this has never been pointed out to your Lordship. Lord, I'll not take much of your Lordship's time, Lord. At maximum
First tell us when it was allowed. First,
4/9/2023.
4th September 2023, and my lord, they have subsequently said that they are supporting us.
No, I never said so. Where have you said? Those are something else. Lord, I'll just show your Lordship, Lord.
TV 26 September 2023 order. September 2023.
Yes, sir. What
You need our support.
Application of CAN 4.
4/9/2023, Lord, CRAN 4 was allowed. Lord, I
Subject to not allowed.
Actually, they are successful candidates, and by reason of the
we are not successful candidate. I did not say.
That is a different.
What cannot be misled.
No.
Page. With math 890.
CRAN 4, Lord, in math 890. So that is not the order.
That is
When was it allowed?
Lord, 4th September 2023.
yes.
4th September. Or that is Justice Talukdar's order?
No.
That's
My Lord,
tenth
just
order.
Your Lordship would kindly come to internal page 17 of
We are coming.
Sorry. My Lord, the record is satisfied.
4 with 8, 9.
September and 26. Lordship has got Lord the order, Lord.
4 September they are allowed.
62.
Which paragraph?
Paragraph 62, Lord. Lord, it's internal page 17, Lord, the cran 3 with cran 4 with cran 5. It's at page, internal page 17, and then, Lord, internal page 18, cran 6, 7 in math 890. Yes, we have served.
And the appellate in Matt 890.
It was allowed in their presence.
26 তারিখের অর্ডারের সঙ্গে এর অর্ডারটা মিলবে না দেখুন 26 তারিখের অর্ডারটা দেখতে বলুন এলাও হয়নি তার মানে
You are appearing for the applicants in
Cran 4.
Mr. Biswas, why don't you send for Mr. Dotto? Call him. Call Mr. Dotto. You are the applicants in CAN?
CAN 4.
5, 6 and 4, 5, 6, 7.
Lord, I am appearing, I am supporting CAN 4.
Are you supporting? Are you the applicants there?
Yes.
Then why you are saying supporting?
Because there are other applicants, Lord, that is the reason, Lord. In
CAN 4,
CAN 5, 6, 7, there are
I'm
other.
not concerned who you are appearing
I'm
for.
appearing in the applicants for in CAN 4.
Yes. What is your, what point you want to argue?
Lord, Lord, your Lordship, Lord, kindly take, Lord, your Lordship would kindly take, Lord, my CAN 4, Lord, for a second.
With 8, 9.
And I have just for your Lordship's perusal, Lord, I don't want to burden your Lordship, Lord, with lot of papers. I've just made few pages compilation which contains the order which is there, which are, Lord, part of all records. These are the court's order, and, Lord, one comparative chart which I have referred in my CRAN 4 also. This is just for your Lordship's perusal, Lord. I don't want to burden your Lordship with.
When Mr. both Tiwari submitted, we had no signs about any other applications.
No, Lord, I was there.
I don't know because we extensively heard the Tiwari brothers. Then Mr. Bhattacharya came.
No, Mr. Mojumdar argued.
Continue doing like
Lord, I'm
this.
sorry,
It's
Lord.
very difficult.
Mr. Mojumdar argued, Lord, after Mr. Mojumdar.
Neither inclined to restrict your submission only to the new point. You come with 3 compilations at this stage.
Lord, for satisfaction.
You have to argue a point which has been left over by Mr. Bhattacharya.
Indeed, it has been left out. Lord, kindly allow me 2 seconds time, Lord.
Yes,
I'll satisfy you.
No, leave that with you. You make the submission. What is your argument?
Lord, my argument is, Lord, that these are the applicants who have scored higher marks than the candidates who have been selected. I'm a more qualified candidate than the others. How I am saying? Because of the reason, Lord, during the pendency of the REIT applications, the board was called on and directed, Lord, to supply the breakup marks of all the 32,000 candidates along with the persons, Lord, who have been selected. Lord, one, in this Priyanka Naskar's matter, when it was going on, Mr. Biswas was directed to produce, Lord, the breakup marks of the REIT petitioners, district-wise, category-wise, medium-wise, everything, Lord, the way, Lord, it should be prepared. Now, Lord, we have, subject Lordship kind sanction, Lord, we just wanted to show your Lordship, Lord, these particular applicants, that the person who have scored lesser marks, breakup marks, has been appointed. I just wanted to demonstrate that. That is the reason, Lord, I have annexed, Lord, all the marks obtained by the applicants. And I have made a comparative chart, which Mr. Mojumdar only referred, but has somehow, Lord, Mr. Mojumdar has not explained that. I just want to that particular part, nothing more, nothing less. Lord, I'll just show your Lordship, Lord. If your Lordship would kindly.
Mojumdar was for the para teachers.
No, Priyanka, some of the applicants. In Priyanka Naskar's matter.
Some of the original.
In Priyanka.
You submitted before Tiwari, na? Before,
Yes, no, after.
after Tiwari.
There are 5 lead petitions. There are 5, মামলার পড়াটা দেখালে বোঝা যাবে।
You were for the applicants in scan 6 and 7, some of the applicants.
Yes.
5, 6 and 5.
You preferred separate read petitions?
Ye-
Priyanka Nashkar is the original petition.
No, may I just refer one order?
Yeah, just one. You
Maharaj.
were, you,
There was a number of petitioners in that matter. Some of them were represented by Mr. Tiwari, some by
I didn't follow. Which one?
Priyanka Nashkar's matter.
Uh,
But a number of petitioners.
140.
Some of them were presented by Mr. Tiwari
Hmm.
and some by
Then why have you made further application? You were there already. You are not within those 140. Then why you are then what was CAN 6 filed for?
Petition. Rest of the rest of the applicants. Look, there are read petition number.
140 applicants in the Priyanka Noshkor's matter.
There are another 5 read petition, 4 read petition, 2, 3, 7,
We are
6,
not
1.
concerned with that read petition.
No, that was.
We are with Priyanka. We are with Priyanka, and the leave to appeal applications which were allowed and regular appeals were registered, 43 appeals.
The CAN which was allowed are the applicant in read petitioners in WP number 23761, WP number 23763. Lord, if your lordship would kindly take Lord one order dated 20th December. May I just read, Lord? No. Lord, my read petition was in November 2022. The Priyanka Noshkor's read petition was September 2022.
So, any order was passed in your read petition?
Lord, yes, your lordship would kindly take Lord one order passed in Priyanka Noshkor's case, Lord, order dated 20th December 2022. There, Lord, I'll just read it for your lordship, Lord.
Read it.
Along with this matter, 4 other similar matter, namely WPA number 23761.
4 read petitions.
Ours is Lord 23763, which is our read petition of 2022, WP number 24551 of 2022, and WPA number 24046 of 2022 are being moved by some other petitioners.
So the annexures you have made in this CAN are the same annexures in the read petition?
Yes.
Huh?
Yes.
Same.
Lord, I have annexed the.
No separate, no new documents are there. Have
No,
you checked
nothing.
up?
Nothing.
So your read petition annexures you show and your CAN application annexures you show.
CAN to amra nutun document diyechi because CAN no Lord, it would be different because when I have filed the CAN application by this time the breakup marks were supplied. So Lord, we have annexed Lord the breakup marks for the purpose of advancing argument before your lordship. Lord, in CAN Lord only we have supplied the breakup marks given by
and
the orders passed by these
petitions.
I
see the order of December 2022 of Justice Gangopadhyay. See the writ petition was nothing. You
Lord,
show one line, it is not.
we really did not, Lord, since Lord, the seniors, Lord, were arguing and were advancing their argument, Lord.
Is it not
I really
written,
did,
sir?
but Lord, I have, when your Lordship, Lord, started taking up, Lord, this matter, Lord, I was present, Lord. I have also, Lord, marked my presence before your Lordship that I am supporting one of the application, Lord. I'll not take much of your Lordship's time, Lord. Your Lordship would kindly, Lord, give me, Lord, 5 minutes time, Lord. I'll be concluding my argument because I just want to show, Lord, on that particular point. The alarm is on.
Emergency silent.
Maybe. Now, Lord, কতজন applicant? 50. আমি কিচ্ছু না, আমি খালি breakup marks.
890. Yes, what you are saying?
Your Lordship would kindly take, Lord, page. No, breakup marks. আমি ওর বাইরে যাব। Your Lordship would kindly take, Lord, page 200, Lord, 16. No, sorry. 220. Annex ke PA. Lord, this one.
এখানে রেখেছিস
আমি তাই না
আমাদের কাছে কপি
নালে ক্রান অ্যালাউড হলো কি বোর্ডে ওকে সার্ভিস করেছি নোটিস করেছি
page 216.
Might kindly give me a second, Lord. They are asking for a
216.
yes, Lord. 220. And Lord, page 1. There are two, Lord, pages, Lord, I'm going to rely on. One is page 220 and 162 because
So
these
this
are the
page was not there in the spiral binding
no,
considered
Lord.
by the
No.
because this different petitions.
Yes, what you are
This is big. This is, Lord.
One thing I have to point out now is
Mr. Sannal,
No.
let him conclude. Let him conclude. You will get your chance.
the board doesn't have this application either.
Wait, Mr. Sannal, we will arrange. We
Mr.
will
Ratul
don't
Mishra
worry. We are
accepted
not
it.
going away. We will hear you. Yes.
My Lord, these are, Lord, breakup score in the this is a breakup score in the recruitment process of primary teachers, Lord, held in 2016.
Yes.
Lord, this is in taking into note, Lord, as I said, Lord, there are orders passed by this honorable court directing, Lord, the board to supply, Lord, the breakup marks.
So, which one you are referring to?
Lord, this is, Lord, your Lordship would kindly take, Lord, this is the list of the candidates who have scored, Lord, your Lordship would kindly take the right side part.
Yes.
These are the breakup marks of the selected candidates, Lord, 12.546, 12.582, 13. Lord, these are the numbers, Lord, 16 and odd. Lord, we have picked up, Lord, since, Lord, there was a district-wise list also. Lord, we have compared the chart. Lord, that is the reason, Lord, I was just trying to show your Lordship, Lord.
No, show it from the application.
126
Page 220 with which page do you want us to see?
226.
222 of the CRAN.
220.
20 of the CRAN 4. Your Lordship has got,
Yes,
Lord.
yes.
That is the breakup score in the
Canford, yes.
that they have supplied it. Lord, my contention is that after scanning the document, because there are 3 breakup marks document was given pursuant to the order of this honorable court. The board supplied, and we have make a comparison chart. The comparison chart shows that in Purulia district, Lord, if your Lordship take, Lord, one OBC candidate who has been selected.
Show us from where in your application, which page?
Your Lordship would kindly take, Lord, the first person is Pratik Das. Applicant number 1. Page 220, your Lordship has seen, Lord.
220, yes.
Top, Lord,
Pratik Das, yes.
Pratik Das. He is a category, OBC category.
Yes.
His total marks is, Lord, 21.997. Now, Lord, the next, Lord, candidates who are in the same district, despite getting, Lord, lesser marks,
486 candidates.
there are as many as 486 candidates, Lord.
Wait, where is the district here?
The district code, your Lordship would roll number 17 means blood district Purulia. It's every district has a code.
So the beginning numbers are the district.
District
17.
Malad.
So 17 is for Purulia.
Puruli.
Yes.
Now, my lord, the next candidates.
426 candidates.
There are as many as 426 candidates who have got lesser marks than me have been selected.
Where is that?
Now, this is the list. This is the chart.
No, this is next name is Sudev Kanti Banerjee.
My lord,
He is
yes,
general category.
he has code blood.
He is of general category.
Now, my lord, if a candidate, my lord, if OBC candidate scores higher than the my lord, general candidate, he will be treated as a general candidate. So, my lord, even if Lord, your lordship, Lord,
Your general candidate obtained 12.545.
that is the breakup mark given in respect of a selected candidate. I have got Lord 21.997. I'm talking about one applicant. And there are as many as 426 candidates in Purulia district only.
Same category.
And the same category, general, including OBC, all have been selected, but I have not been selected. So, Lord, if your lordship would take, since Lord, the breakup marks were supplied by the board, I'm not relying on my document. During the hearing of the proceedings, the board supplied the document. From their document, it is seen that the less meritorious candidate has been selected.
Yes, anything else?
Lord, for this is, I've just referred, Lord, one candidate in all the applicants who have secured higher marks than Lord, the candidate selected out of that 32,000 have been placed in the merit list and they have been selected. But I have not been selected. Lord, my deprivation is based on their document which they have supplied during the course of hearing. Lord, this is one, and Lord, and then this is one district, Lord. I'll just show Lord another district, Lord, from page 237. এটা পুরো আমি সবটা দেখাচ্ছি না, মাইলরটা অ্যাবডাক্টে দেখাচ্ছি এবং বলছি প্রত্যেক ডিস্ট্রিক্টে এটা হয়েছে। Now, my lord, your lordship would kindly take Lord page 233 for a second.
Give us the page numbers.
My lord, Lord, district wise, Lord, I'll give the page number here and now, my lord. Your lordship would kindly take Lord page 233 for a second. Yes. This is Lord, code is 09. Second district. 09 is not 24 Pargana. Rinki Pal is the blood applicant before your lordship. She has got 18.399 breakup marks, but the other candidates, there are as many as 1,286 candidates who in the same district who has got lesser marks, but they have been appointed. 18.399.
20.421.
No, but the candidate who have been selected, Mr. Lairi, when you reply, please take note of that. I'm not going to answer your queries. And Tonusri Mukhopadhyay, who is a general candidate, got blood 12.744 and has been selected. There is Mrinal Roy, general, who got 12.787. He has been appointed. And rest on, there are as many as.
It is which subject? It is which subject, which medium? Everything is which subject, which medium?
Lord, everything, Lord, your lordship would kindly
come to rule 8.5.
Well, there is no sub.
Satisfy us.
Lord, I'll say.
Where is the median?
Breakup number, Lord. That is the reason, Lord.
That we have
roll number, name, then category 1. Category is OBC, either or OBC or.
Where is the medium? Which subject teacher?
Subject is not.
Yes.
Lord, in primary subject, Lord, subject, Lord, you can sanction.
Highly come to sorry.
It's all medium. It's medium.
Medium wise, yes.
And they have Bengali medium. They have also blood given them blood.
Getting that Bengali medium.
162.
Page 162 is their list.
Page 220 you are showing.
223 I am showing, but
220.
223, 233 I am showing, but the basis is 162 in the same CRAN which have been supplied by them.
We are wanting to know the medium.
Lord,
You
medium.
don't know where which your client is in which medium.
Bengal medium, Lord.
Where do we get?
Lord, this is the way, Lord, they have given us the document. Lord, we have make a comparative chart based on their document. It's not, Lord, my document. That is my contention is.
Page 162.
62.
162.
I'll come. Arre, my lord,
The breakup marks you have provided.
Lordship has got, Lord?
162.
My lord. Opted district, Lord, is the code and all.
Yes.
Then medium, Bengali. Roll number is given. Candidate's name, your lordship would kindly take, Lord, top. Candidate's name, candidate's category, candidate's caste, TET score, Madhyamik score, HS score, training score, Viva marks, aptitude test, extracurricular activities. Look, this is a document which has been supplied by them. During the course of hearing, I have picked up the score sheet from their document and made a compilation for your lordship's reference. They cannot deny because the document was supplied pursuant. I'm sorry.
33.
ঠিক আছে সব দেওয়া হবে
Is not appointed. Not appointed. Now, my lord, that is the reason, Lord, I just wanted to give the sequence.
62 is a can for
160. This was not appointed, but in another writ petition, they have supplied the breakup marks of 32,000 people. In Ramesh Mullik's matter, pursuant to the order of the court, they have supplied the document. So, in three, what we did, 32,000 breakup marks, Lord, we have got our marks also. Now, Lord, that based on these two documents, we have made the compilation which Lord I have shown to you.
Let us hear them. What is the explanation?
No, this,
your contention is persons who are seeking lesser marks than you have.
Less, Lord, this is the contention, and Lord, subject lordship kind sanction, Lord, they might say that this document was not supplied by them and all.
Which document?
Lord, the document, Lord, which three documents which I am relying on, and I have made the compilation based on their document.
Their breakup.
Lord, yes. The order is also there. I just wanted to refer the order, which is
take note of that, Mr. Biswas.
Page 156 is the order passed by this honorable court. Lord, I have supplied the Mr. Biswas received it.
Breakup list is there with you.
Breakup is there.
He has supplied.
They are referring to a particular application in connection with a particular appeal. Those appeal have not been filed by the board. So they have not filed that CAN application to us.
Lord, I myself.
So we have to go to their application first. I have to
But
see
the
the next.
application allowed in front of you. Now you are saying at the last moment, I did not get anything, my lord.
Mr. Vishwas received the CRAN application.
My lord, your lordship has seen the one order, my lord, allowed the can, my lord, the
Breakup mark
I have, sir, Mr. Vishwas received himself in court number
by you. Breakup has been
8.
published by you. So this is from the breakup list which he is pointing out.
Well, how do I know that from that backup unless I get the application?
Oh.
He has served a copy, he said.
That's what I.
You
Mr.
are not appealing for the board, Mr. Sharma.
I'm appealing to the board.
Watch.
Well, I'm led by
It's confusing, Lord.
You appeared for the para teachers, no?
My lord, one of the appeals I appeared all throughout. I appear for the board. I once informed your lordships.
You made extensive submission on the basis of para teacher application.
Only, but all of them are, my lord, either Advocate General or Mr. Lokhe Gupta, all of my seniors otherwise. So that's why I could not make any submissions.
Then you two would have apprised Mr. Dotto.
I once last but one occasion I apprised that before lost.
No, apprise Mr. Dotto as regards this fact that backup list is with us. Give him the copy. He
Well,
will
here-
take up and come.
This would be the third time, I guess. Lord, Mr. Vishwas,
which is application.
Mr. Vishwas received it, Lord, from me.
Very good. You give one copy to him and take back that copy.
No,
And
obviously.
you may you cited the page numbers 230, 220, 233.
Lord, 162, then Lord, 221 onwards. Because in
62 to 221 onwards.
Lord, yes, 221, 220 onwards. Because I have compared Lord district wise. I picked up one petitioner, one applicant, and then Lord, I have taken out the numbers of other candidates, Lord, of 32,000 from the same district and made a compilation and comparison chart that I have got higher marks than those 32,000 people who have been selected. District wise.
আমি পাই না
সবাই পেয়েছো সবাই এভিডেভিট অফ সার্ভিসও আছে হ্যাঁ এভিডেভিট Lord, the breakup marks, and if a candidate has got Lord higher number than the person who has been selected, our Honorable High Court in a division bench in the same recruitment process, Lord, has considered the breakup marks and directed appointment. Board was a party, and Lord, this is an unreported judgment, Lord. Ajmail Hawk, Lord, your Lordship would kindly take, Lord. This is yeah, দুটো আছে।
Ajmail Hawker judgment. Ajmail Hawker judgment. Malla. Just standard, very standard.
Paragraph.
Appointment. Appointment.
MAT 1309 of 2019. সবাই refer করে। MAT 1309 of 219. 14 March 2022. Lord, there the finding was, Lord, one of the candidate.
Show us that compilation, your comparison you are taking.
Last page today.
এখানে ছোট করে করে যেহেতু ওটা 60 পেজ তোমার ওটাও নেই
It starts from Lord page. This is more precise, Lord, based on Lord 220. Just Lord, so that your Lordship, Lord, I said, Lord, I do not want to burden your Lordship, Lord, on lots of documents.
only order sheet
Page 60 onwards.
60 on 60
Give copies to Mr.
I have given. Lord, there, Lord, I have specifically stated, Lord, as I said, Lord, the code, district-wise code,
Page 60.
60 onwards. Rest are, Lord, all orders, Lord, passed by this honorable court, because this would be reference, Lord. My sole intention was that,
Yes, what?
now, Lord, it says, Lord, the first breakup point, Lord, so far Pratik Das is concerned, Lord, I have shown, there I have specifically stated that following 3 out of 426 candidates from Purulia district who have scored less than Pratik Das in CRAN 4 of 2023 in math such and such, they have been appointed. There are 426 candidates. Now, Lord, then next is, Lord, North 24 Pargana. There are as many as 1,286 person who has got less marks than Rinki Pal has been appointed.
In same district.
In the same district. Now, the second district is not one Gobindo Das, who is an applicant. There are as many as 185 candidates who has got lesser marks but have been appointed. So my sole contention is that the less meritorious person has been selected. And that was my first.
How many applicants are there in this can?
50.
In your can?
CRAN 450 candidates.
Now, what is the mark obtained by those 50 candidates where you
I have given, Lord, that is the breakup I have given. Just hand over, Lord, the compilation. Page 60 onwards, Lord. Applicant 1, applicant 2, applicant 3, Lord, in that way.
Pratik Das, Rinki Pal, Govind.
Lord, Pratik Das is applicant 1.
Applicant number 1.
Rinki Pal is applicant 2. Govindo Das is applicant 3. Vishwajit. I'm sorry.
Pal, Govind Das, fine. Their marks.
Would your lordship pleasure, Lord, to take one page, because I'll be able to, Lord, apprise your lordship, Lord. I have also given the applicant number. Lord, in the bold line, the second part, that following a 3 out of 426 candidate from Purulia district who have scored less than Pratik Das, bracket, Lord, petitioner number 1 in
Yes.
CRAN 4. So in that way, Lord, I have explained 1, 2, 3, 4, like, Lord, all 50s.
Yes, judgment what you are showing.
Lord, I was just showing, Lord, based on these breakup marks, Lord, who have, your lordship would kindly take internal page 2, Lord, in course of hearing, 3rd paragraph. We directed the West Bengal Board of Primary Education to produce the relevant records pertaining to the marks obtained by the petitioner. Such disclosure would reveal that the petitioner, namely Ajmail, obtained 14.375 and the other candidate, namely Milton Islam, obtained 14.438. We do not perceive any reason for disclosure of the aggregate marks obtained by Milton Islam, who neither filed the writ petition nor aggregate. Now, Lord, based on, your lordship would kindly skip over all these paragraphs, and then, Lord, your lordship would kindly take the finding. And then, Lord, your Lordship would kindly take, Lord, the internal page 3, last paragraph. Since the appellant petitioner has not questioned such procedure having opted by the board, we do not want to go into the such as the contention of the appellant petitioner is all along that he having secured higher aggregate marks than the person shown in the said category, he should not have been spared. As indicated above, that the petitioner obtained 14.357 marks in aggregate, where the panel of the exempted category contained 533 names, including the name of the candidate brought from the general category, having obtained lesser marks than the appellant petitioner. Then, Lord, I'm skipping over other aspect. The ultimate direction was given to the board. The West Bengal, I'm just reading, Lord, the paragraph, page 5, last part 1 paragraph. The writ petition is allowed. The West Bengal Board of Primary Education is directed to give appointment to the appellant petitioner showing his name between serial number 50 to 51 in the exempted category within 2 weeks from the date. Look, that was though exempted category, but he got higher marks than the person who. Look, কেন ওখানে
do you get?
Lord, I was subject,
Your
Lord.
petition is pending.
Yes, because it has been adjourned.
Today, suppose we set aside the recruitment process and affirm the order of justice of the writ court, then you have to go for a fresh examination.
Indeed.
So your writ petition goes, even though you have a valid case that I have been
Lord,
superseded.
I was beseeching your Lordship, Lord, to take away a middle path. That the part,
Pardon?
Lord, I was beseeching your Lordship, Lord, to appoint us in the vacant line, the post lying vacant.
That is not your appeal. That is not the writ petition.
Lord, in the writ,
You have an independent writ petition.
Lord, yes.
If today the court
Petition
sets aside this selection process, what benefit do you get? Then you have to go and again participate in that proceeding, and your writ petition becomes infraction.
Lord, with the expectation that a fair
What
selection.
expectation? You put your own throat in the process that you add me as a party. Forget about my writ petition.
Here you cannot claim a separate right other than what's claimed in the writ petition and the appeal.
No,
You are
Lord, in
merely
the,
addition of
you are
party.
in the writ petition, subject Lordship, kind sanction will prayer to
No, Mr. What we are trying to say is what was your prayer in the writ petition? Give me appointment.
Yes.
Because I have been superseded.
Obliged, Lord.
Now the entire process set aside. You close your eyes. You said, oh, it has been settled. Now let us go and join there so that I can also come within the purview.
Lord, my writ petition is still pending, kept adjourned sine die.
You cannot take both. Then you withdraw the application for addition.
Because your Lordship would no, your Lordship would kindly appreciate.
It has been allowed also.
Yes.
So how can you disengage yourself from
because
this?
ultimately the issue at large is going to be decided before this honorable court. So, Lord, my right of audience will not always accrue. And Lord, I have a right of participation in the.
You are an addition of party. Why addition of party? Principal, necessary or proper party. To establish the challenge in the writ petition or to establish the objection against the writ petition. That is the purpose of necessary and proper party. Now, if you have added as a party, what can we see? This is an outright illegality. Juniors have been given less marks given, they have been given. We accept your argument and we set aside the selection process. What happens to you?
I'll get chance.
Does that give you any sort of window to go back to the writ court and say that that the selection process has been set aside?
Order sheet আছে তুই আগে order sheet বের কর ওইখানে adjourn sine die করো
Writ petition, your challenge in the writ petition goes.
Lord, in my case, Lord, what has happened, Lord, and the order has been passed is by the Honorable Single Bench is page 38, Lord, which I have given. It is said, Lord, the learned advocate for the petitioner submits that in these matters, the judgment and order passed in this matter means not in my matter, Priyanka Noskar would be applicable, and therefore the matters are not required to be heard at this stage. It can be heard if and when situation arises in future.
Because
So,
I have apprised. That is an interim order pass. We are asking an answer from you that what will happen to this.
No, Lord, my writ petition is still pending subject to lordship kind sanction because of the reason, whatever is the outcome of the Priyanka Noskar's matter, Lord, that will be governed, and I will have my
Dug your own grave. Isn't it? Who told you to get appointed? You had a good case. See the breakup given. I am secured.
No,
in
that
my-
is only when the appeals were paid. Lord, by this time, Lord, the matter was adjourned, signed, and nothing was. When the appeals were being asked, we could get these documents. So, Lord, our intention was to put before your Lord.
Everything
Lord,
said and done. How can we help you? Tell us.
Lord,
Your argument we can accept for the purpose of setting up a ground for setting aside this election process. But we cannot accept your argument that give me appointment. Can we make that prayer?
there are
Can
Lord, there are vacant posts, Lord.
So by being an addition, are we directing Priyanka and others to be appointed? We can either set aside the process or we can set aside the order review.
My Lord, one judgment has been cited by the board. Lord, there I could find, Lord, one paragraph which could be some of the help of the applicants. Lord, that is, Lord,
Compensation.
no. Lord, Ranbijay Singh, Lord, paragraph 35, Lord, the Honorable Supreme Court took, Lord, the middle path. Lord, if your Lordship would kindly, Lord, board has cited it.
Tell us.
I'll just read that particular paragraph, Lord, if your Lordship so desires, Lord. It says, Lord, having weighted the options before us, we are of the opinion that a middle path is perhaps the best path to be taken under the circumstances of the case. The middle path is to be declared that the third set of results, since the board has undertaken a massive exercise under the direction of the High Court and yet protect those candidates who may now be declared unsuccessful but are working as trained trained graduate teachers as a result of the first or the second declaration. It is also possible that consequent upon the third declaration of the result.
Middle part here.
Lord,
There is only two paths. Either affirm the judgment or set aside the judgment.
Lord, the case of this particular applicants, but
can we go into that your issue? You are citing that, see, these are the illegalities, blatant illegalities. You have asked me, you know. Now, on the basis of your argument, we can set it up as an additional ground if we are inclined to accept your stand that yes, the process is totally wrong. Anyway, yes, thank you, Mr.
Lord, so far 165 and others, Lord, many have argued. Lord, I'm not.
165, what you will?
Lord, I don't want to argue.
Again,
Lord,
for the purpose
Lord,
of
I'm not. Lord, that was only. Lord, I just wanted to point out.
Give an answer to us what my brother has asked you. You have not answered my
Lord,
brother's query.
Lord, our writ petition was, the prayer was for appointment.
You tell us, we are recording here, that your question of entitlement for appointment can be decided in this appeal. You say that, we will record. You say that, we will record.
So yes, this can be, your Lordship would kindly record my submission that my right of appointment can be decided in this appeal also.
You are an addition of party applicant. That process is illegal.
No,
you are
because-
adding yourself for necessary adjudication.
Lord, my writ petition is still pending. Lord, that is the reason, Lord, I'm beseeching your Lordship. Lord, whatever is the outcome.
Go to the writ petition after, if we set aside this election process.
Lord.
Go to the writ court and say that give me appointment. Then the writ court say. Thank you, Mr. Ram.
I have taken out an application for cat number 106.
বলছি বুঝতে পারছিস তোমার তো এখানে ধরো সিলেকশন হলো না হয়ে গেল সব হয়ে গেল তো ওখানে কি তুমি বলতে পারতে এটা হয়ে যদি সিলেকশন প্রসেসটা ক্যান্সেল করে দেয় তাহলে তো হয়েই গেল
going
আর কিছু
the decisions of the notice. So for paragraph 22 of the judgment is that kindly create on the board call us so that we can also participate in terms of paragraph.
Oh, before setting aside the selection process,
Ultimately, this selection
which is your application
106 and 106.
was allowed when?
Not allowed.
It has not been allowed. Sorry.
Kindly allow the application. We had already participated in paragraph judgment say the public secretary has the board has immediately arranged necessary for candidates who were elected at the time, including candidates who are opted training for within a period of 2 months from the date other candidates.
So that is a question of interpretation, Mr.
We were interviewed.
Very good. You wait for the opportunity. Whether we are upholding or not, that will come. We cannot modify the order, sir. That is, you are saying that I am coming within that definition.
Only thing board may be directed to allow us to participate in terms of the
The preemptive argument, we have not yet touched. And after we touch, we cannot add to the judgment.
That's why
We cannot add to the judgment.
ultimately
This is scan 106 in connection with which appeal? 106? MAT?
Lord, I have two applications, 109 and 121. Those have not been,
When have you filed it?
it has not been allowed, but our stand is that we do not come under the purview of untrained candidates because we had got TET qualification with,
What you are saying?
we do not come under the purview of untrained candidates. Reason being, we were appointed with TET qualification with B.Ed. Now, as per subclause 8 of clause 8 of the recruitment rules 2016, your Lordship has already considered that first the trained candidates will be taken up, thereafter the untrained candidates will be absorbed. So our initial path of entering into the process was valid in terms of the statute. Secondly, my Lord, we have already been given the A category scale of pay, which is given for the trained candidates. A category scale of pay is given only to the trained candidates. So the state authorities, state of West Bengal has already considered as to be a trained candidate, for which we are getting the A category scale of pay. Lastly, my Lord, there is a decision of the Honorable Supreme Court in Devesh Sharma, your Lordship has already considered. Though the issue was different, it said whether B.Ed qualification is a valid qualification for the primary teachers, where the Honorable...
Who are you? You are?
I have prayed for addition of parties. We got the appointment as state qualified B.Ed with B.Ed candidates. Our
State qualified B.Ed.
B.Ed. So we were treated as untrained at that point of time when we were appointed. Subsequently, I mean, yes, we are working at 17 to 19. We completed the breach course as well as per the requirement.
When you are working, why you are making an application?
No, the reason being
What, higher grade.
Higher grade. Now I'm telling because they are trained. We do not come under the purview of untrained. That is why I have come, so that if the untrained are not allowed any further, we should not be coming within that purview. Moreover, my Lord, the Devesh Sharma's judgment, your Lordship,
What? You are not coming within
the purview of
untrained.
We do not come within the purview of the untrained candidates because we have already completed our this breach course, 6 years breach course and DLED 17 to 19 when the writ petition did not see the light of the day. It came in 2022. Even much prior to that, we had completed the training course as per the NCTA notification. Now, my Lord, our initial appointment was as per Yes, can want to. These three submissions, four submissions I have in regard with these two applications. So we are trained candidates. We may be declared as trained candidates.
So, Mr. Bhattacharya, learned senior counsel, appearing for learned senior action or action. Applicants. Mr. You conclude on we are sitting a 4th of November we are keeping at 2 p.m. You conclude your reply.
only one my application
Just a moment.
application add করতে হবে order হয়
Last but one occasions probably pointed out to or wanted to put me certain queries or that. May I know all these?
Yes, yes, we shall let you. And you conclude your argument, reply on that part.
Will try my best, madam.
My lord, we shall not take much time before lordship, my lord. We have filed certain cans, my lord, that has not been allowed as on date, my lord. We'll my lord, each, my lord, only 1 minute.
My
can, my lord.
It's the matter for
my
further
can may be allowed my lord
on
Well, that is only on the different aspect altogether, my lord.
on 20 on 4th November 2025 as fixed at
Well, kindly allow us, my lord, before this starts, my lord, kindly allow us.
cannot be done.
Well, we shall
Applications
not
were
repeat, my
last
lord.
received and stopped.
Well,
We
shall not
cannot
repeat
go on
anything.
adding applications.
No. It was filed in 2024, my lord. We shall not repeat the submission, whatever has been submitted before your lordship, we shall not repeat. Well, kindly allow us only 30 minutes. Prior to this starting reply.
Then enough, we have heard want to add.
My lord, we didn't get any chance, my lord. Kindly, my lord.
my lord my can is different my lord
May I make one? Madam, may I make one request?
Well, only concept. Well, Mr. Bari is leading me, well, kindly, well.
May I make one request? Madam? Instead of 4th, would you also take up on 6th? Is
No,
any?
Mr. Sanar, come on. What we are not hearing everybody else. We will hear the reply of the board. And any one of you want to submit, you submit. We will not prolong this hearing any further. We have heard enough. Heard enough. Mr. Mojumdar, you sit with your other friends and you argue before us telling the points, we will assimilate. Please.
But only one.
Kindly grant us 10 minutes, my lord.
Mr. Joydeep.
Only 10 minutes.
No, Mr.
Joydeep was at the time of hearing.
No, we said, but it is becoming impossible.
It will take,
We
take only
cannot
10 minutes.
unnecessarily extend the.
I'll take only 10 minutes.
Yes, 10
at the
minutes.
time of reply.
You tell to Mr. Mojumdar what is the point, he will tell you. Or any Mr. Sen.
Mr. Paul is leading me. He'll take
No, this way we cannot proceed. We have requested enough to all the advocates, but now it seems it is going beyond bounds.
At the time of reply.
My prayer is different.
My lord, we didn't get any chance.
They were giving the charge sheet.
Mr. Lairi, Mr. Sen, we have made ourselves clear. We will hear Mr. Dotto or Mr. Sannal who appears for the board. We have queries for them. You please let us know through one advocate that what are the points in reply. We will hear so that we can say we cannot hear 15 advocates. No. Your senior most person's chamber will be attended by all the learned counsel. So
but I have not been given, but I'm not.
My lord, my prayer was different. My lord, my prayer was different, my lord.
Mr. Laidi, we have heard you. If ultimately we wish to allow your application, we will allow your application and it will be guided by the judgment which we will deliver.
Very well.
Well, for our application, kindly grant us 10 minutes only, 10 minutes. On the next it.
30 minutes it has come down to.
My lord, since your lordship are not allowing 30 minutes, so kindly 10 minutes maybe. My lord, kindly, my lord. My lord, Mr. Badi is leading me, my lord. My lord, we have engaged, my lord, kindly, my lord.
Let us hear the reply, then.
My lord, we will be urged, my lord, some new points, my lord. We shall not repeat the points. All. Kindly, my lord.
Vote only. Mr. Mojumdar, you will be here. Then Mr. Sen will be.
May I buy for 2 days only? 6th, your lordship.
No, Mr.
Then my lord, kindly allow us on 4th, my lord. They reply on 6th.
What is your argument? Which application?
Well, taking cue of Mr. Ahmed's, my lord, whatever submitted by Mr. Ahmed, my lord, that we have preferred.
Which is the application number of yours?
Well, we have filed.
Mr. Alamgir learned.
Well, we have filed certain application on the similar ground. That is application 12 of 2024, 14 of 2024.
Yeah, just. Can 12
of 2024.
12 na 14 bolli.
তারপর একটা 14 বললাম স্যার। Can 14 of 2024.
14/24.
Can 15 of 2024. Can 16 of 2024. Can 18 of 2024.
We'll take 10 minutes just to give this. Continue.
No, our submission is we have followed what has been followed by your lord.
12, 14, 15, 16.
18 also, my lord. My lord, these applicants, my lord, have preferred separate
Is that in connection with which appeal?
MAT 873. Appeal preferred by the board.
Yes.
My lord, we have followed whatever has been followed by has been stated by your lordships, my lord. My lord, if the appeal goes, my lord, we want only an observation since our independent writ petition is pending, and in the application itself, my lord, by way of a tabulation chart, we have shown that people securing less marks, much less marks than us, have been appointed. We are obtaining.
Query we have put to Mr. Ahmed.
Ahmed, yes.
What is your answer to that?
Well, only one thing, but if the appeal goes,
yes,
then my lord, we do not have any case. Since my lord, in the writ petition, our prayer was to give us appointment.
After that, we will again protect your right.
No, only since your lordships are listening the larger aspect, my lord, we are only joining us our issue. Nothing.
Yes, for the prayer of setting aside this election.
Yes.
But after, suppose we will hold either of the way. either set, if the selection process is upheld, that is one thing. If it is dismissed, it is another thing. You were there, we put.
Yes, yes, that is why, my lord, we are not taking much time, if your lordship, my lord. In that case, my lord, an observation by the division bench will perhaps, my lord, serve our purpose. My lord, may I supply the can number to your lordship's court to the identical point?
There is no answer to the query, but you are saying that if it is set aside, protect our right within the
No, no.
pending petition.
If your lordship set aside the order of the single bench, my lord.
No, if we affirm the order, if we affirm, then everything
goes.
If we set aside, the selection process goes.
Yes, my lord. Then we have to apply for the fresh selection process. Then everybody rights goes, my lord. But if your lordship affirm the set aside the order passed by the single bench, my lord, then, my lord, our writ petition should be adjudicated, my lord, independently. That is my prayer before your lordships.
ক্যান নাম্বার গুলো দিয়ে দিলে
Well, I am submitting the can number, my lord, on identical issue. আরো আছে কয়েকটা।
ক্যান ক্যান করতে পারি আমি? দেখি আবার বলবো। চারে রাখতে চাইছি।
দেখি
বলছেন ওরা তো হয়নি, বলেছি বলবো, দাঁড়া কথা বলছে, ছয় হয়ে যাবে।
পরের দিন
The queries from your lordships.
Oh, we will get our answer, Mr. Sharnal, when you meet with the arguments of Mr. Bhattacharya, because he has argued first about that MHRD relaxation was still, but it was not there on the date of advertisement. First. Second is that as regards corruption and fraud, whatever he has argued. Third is he has made a, we put a question to him that TET 2014 was in fact being challenged. Where is the challengement to the recruitment process? And what is the role played by S. Basu and company pertaining to the recruitment process? He said that he was engaged both for the purpose of the TET 2014 as well as for the recruitment process. And in aid of that, he has brought us some documents. That affidavit is placed. Next, he said that even if there is no pleading specifically to the effect as regards the challenge, that Standard Chartered Bank shifting of owners, it will come. That is not required. And today he has submitted as regards the chart sheet, on which the statements you will deal with it. And only one question, the last submission which was made by them, the applicants, relating to the breakup which was published by you. From the breakup itself, it is apparent that persons who have secured more marks have been ousted.
lesser marks.
In addition,
Lesser marks have been given.
Lesser marks have been given.
in addition to that, the selection committee in under Rule 8, my lord.
That Mr. Sharnal has heard. All I cannot do. You give your argument on that, and Mr.
Well,
Bhatt.
only renewing your lordship instead of 4th, 6th, would your lordship possible? Do that, your lordship.
For the board and another day for
Only six. পয়েন্টগুলো মনে রাখতে পারবি তো, ভুলে গেলি না তো?
Solve your problem. Oh,
Five is all. Six. হুম?
7, 8, 9, 10, 11 মিঠুনকে ডেকে নিয়ে fixed at 2 p.m. 6 তারিখ করে আর ওই লাস্টে
কেন অনলাইনে এটা শুনতে পাবো?
লাস্টে ওনার নামটা
না না না, এখন কি
and also you people.
অনলাইন
Sir, Mr. We are requesting you. Please now you consider. We are requesting.
বললো না সেগুলো লেখা হলো না।
While taking short submission, he
Okay.
will
Forget everything.
হ্যাঁ হ্যাঁ লাইভ স্ট্রিম
তাহলে
Very good. On 6th we are keeping. Hopefully if it is finished well and done, but I cannot just tell you that I will not hear.
just one more.
Yes, we are requesting if you can make it because another day you are seeing the further applications are coming. Let us understand in this fashion, 6th it will be concluded. If it extremely it so happens that you are, we cannot forcibly prevent you, na?
Have really, next week I have some problem. Because I will be in and
Pardon,
out of
pardon,
station.
pardon, you 6th you won't be
But
there.
I will be in and out of station 3rd, 4th and 6th. That's the whole difficulty. But my lord, any, let the board conclude, my lord, on 6th.
Acha, let this 6th November come.
Yes,
Let us see,
the Lord
Mr.
is extremely kind to us, but my lord, we are praying for indulgence.
দিনার নাম দেওয়া আছে?
আরে দিয়েছে রে, কেন তোলা হচ্ছে? যাদের নাম আগে বের হতো তাদের আবার থাকবে নতুন করে।
কি গো